Right, may I check whether there's any lag or whether you can hear me and see me clearly?
Your Honor, I can hear and see you very well.
Wonderful. Thank you. Right, we were just dealing with some housekeeping, and I think claimant solicitors are very kindly going to provide the list of issues and the agreed case memorandum. And I think I was asking you, Dr. Bickford-Smith, if you'd be so kind as to send to the court the draft order that we discussed yesterday, the final version in Word. Thank you.
I will do.
Right, and are we ready now for the defendant's witnesses?
Yes, Your Honour, just two very minor pieces of housekeeping. One, you should have got the consultation paper, I think, was sent through to the registry yesterday.
Right.
If you haven't got
I haven't seen it, but I'm sure it's been well received. If not, I will let you know.
The second was really just in terms of preparing witness availability and provisional indications of time estimates, really is to work out what time we think we will need to have Mr. Aslam available. So, for example, if it's going to be after lunch, what time we would end up breaking and so on, so we can make sure that he's in situ and ready to go.
Yes, I can help with that. This was going to be my piece of housekeeping. At the moment, the order I have down, which is obviously an hour out, was to go for 2 hours with, this is in the draft timetable, was to go for 2 hours with Mr. Bellucci Enzo, then to adjourn, then to have a further hour with Mr. Bellucci Enzo, and then to have the remainder of the day with Mr. Aslam. Now, in view of the time and the amount there is to get through with Mr. Bellucci Enzo, what I was proposing to do is to go for, instead of 3.5 or possibly 3 hours 45 minutes with Mr. Bellucci Enzo. And so for timetabling purposes, we could then think about when the adjournment would be best taken, but conversely to go for less time with Mr. Aslam so that we're done today. Now, as I say, unfortunately on my grid in front of here, we're an hour out in terms of timings, but I think that the way I look at it is that Mr. Aslam should be good to go at, by my calculation, it would be 6:30 Gulf, or if that's 5:30 and I've got my timings wrong, my apologies.
I don't have the timetable in front of me, but from what you've said, if you need 3 hours and 45 minutes with Mr. Bellucci, let's say we start at 8:15 a.m. UK time, then we would have a break at 10:15, maybe a 10-minute break, and then we could go from 10:30 roughly till lunch, which would be about 12:15-ish, and we could aim roughly to start around 1 p.m. UK time. Does that sound right, or have I made a mistake? Which would be 4 p.m. But we could, if we could have him ready then. Do all those calculations sound correct?
I'm trying to do the maths. 2 hours. Yes, I think they do sound correct.
So if he could be ready by 1 p.m. UK time and on standby, even if we're running a little late, at least he doesn't have to be ready earlier. Are we all agreed? Yes. Wonderful. So I think it's up to the defendant to call their first witness.
Yes, we'll have Ms. Bellucci.
Good morning. Can I please check that you can hear the court clearly?
I'm sorry, it was a little scratchy.
Can I please just check that you can hear the courts clearly?
Yes, I can. Thank you.
Perfect. And can you please confirm whether you would prefer to swear by oath or by affirming?
Affirming.
Can you please confirm your name and occupation for the court's record?
Napoleon Vellucci Enzo. I'm a businessman.
Please repeat after me. I affirm that I will say nothing
I affirm that I will say nothing
but the truth.
but the truth.
Thank you, Your Honor.
Thank you. Over to you, Mr. Doherty.
Yes, good morning. If I could ask for the assistance of my instructing solicitor just to pull up some page references. First of all, page 311 of the main bundle. Mr. Vellucci, in front of you, you should hopefully be able to. Can you see on screen documents?
Yes, I can.
So this is it's the second witness statement you've provided. It was the first witness statement you provided giving your factual evidence. And if we can go, please, from page 311 through to 327. You can see this statement runs to 17 pages. There's a signature on that page. Could you confirm, is that your signature?
Yes, it is.
And can you confirm that the contents of this statement are true to the best of your knowledge and belief?
Yes.
Thank you. If we could go, please, to page 331 of the bundle. Here you should be able to see a document that says third witness statement, Napoleon Vellucci Enzo. Do you see that?
Yes, I do.
And if we could go from there, please, to page 339. Again, there is a signature on this statement which runs to 9 pages. Can you confirm, is that your signature?
Yes.
And can you confirm, is this statement true to the best of your knowledge and belief?
Yes.
Thank you. If you remain, I think there will be some questions for you from Dr. Bickford-Smith.
Sure.
Good morning, or is it good afternoon where you are? It may be good afternoon. Is that right, Mr. Enzo?
Yes, thanks. You
Do
too.
you prefer to be called Mr. Vellucci Enzo or Mr. Enzo?
Mr. Vellucci is fine.
Mr. Vellucci. On the 5th of April, sorry, I'm going to be relying on those instructing me to screen share the documents I refer to.
Okay.
On the 5th of April 2021, you are copied into an email from Mr. Aslam of Unitas, and this is at bundle 519, PDF 519, hard copy 504. If that could be shared, please. So this is sent to Alina. Was she someone who worked for you? Is that correct?
Yes, she was my PA.
And this is a due diligence pack about Banyan Tree Asset Management. And we see that you can see the list of contents there: bank statements, outstanding balances and sale price, list of ongoing expenses, draft audit report. Now, if we look back at the copy list, we can see that 2 lawyers from Al Safar are copied into this email. They were acting for you with regards to the potential acquisition. Is that correct?
Yes, I guess you could say that. Yeah.
And if we look at the email itself, we see that second paragraph, pursuant to your email dated the 18th of March, we're pleased to attach the requested due diligence pack. So can we take it from that you were told by Unitas about this potential acquisition sometime in March?
March of April to Monday. Yes, I would assume it was March of that year.
And then in your witness statement, and this is at PDF 327, which is bundle 312. Paragraph 7, you say here, effectively you explain the context to this, which is you're looking for a license. It could take up to a year to obtain. You could buy a company which already had one. So you say here in paragraph 8, my interest had nothing to do with the business itself, its staff, or the investments or customers which they had.
Just give me a second so I can read it. Unitas suggested the idea. Yes, that's true. The Banyan Tree was not operating as a private equity fund in DIFC. Their business model was taking customers from the UAE and sending their money to. They had a bank in Mauritius, and that's why they opened this fund. So they were taking money from people in Dubai and sending that to the bank in Mauritius. So they weren't really in the private equity or the private fund management business. They had the license, but that's not what they were operating.
The point, the question I'd ask you is this: it's not just the license, is it? Because one advantage of this entity is that it is it has been set up. It has a compliance function, who are indeed Unitas, who you meet, and it has an SEO. So acquiring this business means that you do not have to recruit and set up from scratch, correct?
Yes.
And now, if we then go over to 507,
well, I would sorry, I would correct that. I wouldn't say I wouldn't have to set up from scratch. I would be setting up the business from scratch, but the license itself, which would take about a year to do, if I set up from scratch, would take a year. So I would still have to set up the business from scratch because they didn't have a business set up in the way that I was going to operate the business, which was in the UAE.
Yes, but my question to you is, it's not just a bare paper license. It actually has a compliance infrastructure, and it has a compliance provider. It has an SEO. I mean, it is a functional business, so you don't have to recruit people to perform those functions, correct?
Correct, yeah.
If we go to 522, which PDF 522, this pack is a very long pack, but actually if we see the contents page here, we see that a large amount of this pack is just bank statements. Would you accept that the key materials here are obviously the price, the outstanding balances, the ongoing expenses, and then the audit report?
So, yes.
And let's go through these in turn. If we could go to PDF 631, which is bundle 616. This is at the outstanding balances and sale price. So we see at the top the DFSA license fee, we see Rethink, we see Russell Bedford, the auditors, Unitas, anticipated cost of audit. So that all comes to $69,000. Then we see a sale price of $100,000 and the introduction fee of $20,000. That makes a total of $189,294. So pausing there, you knew that if you bought the business there and then, the price would be in the region of $189,294, correct?
Yeah, just let me look over the document real quick. Think. License fee, rethink. Yeah, I would have to know. The DFSA license fee was probably because it was coming up for renewal. I'm not sure which month it was coming up for renewal, but that's probably why that was in there. It wasn't being paid from behind that let's say they paid for the DFSA license fee 6 months before. So the renewal must have been coming up soon. So that's probably why that's in there. So yes, this looks correct.
And then we have 2 pages later. The ongoing expenses, and we can see there the SEO is listed as an expense at 13,000 a month, and then dues SEO, which is, you know, mandatory in the UA in the DIFC. So pausing there, you knew that each month these sums are the ongoing expenses, and you see it says post takeover, correct?
Let me see it real quick. Ongoing expenses post takeover in USD. Yeah, post takeover meaning that once I took it over.
And we also, just on a briefer point, we have 2 non-executive directors who are at $1,700 a month, correct?
Yep.
So right from the start, you know that this is not just a question of buying a bare license. You've got a business which has got some liabilities, and then which has some ongoing expenses associated with it, correct?
Well, it depends how you're defining business. It was not an operating business. It was bringing in money. So it was are you defining it by a company that's actually doing business, or just that it has a license to do business?
And you say with regards to salary, you say at page, this, to go back to your statement, this is PDF 328, paragraph 11, line 4, we've covered. And then you see there, line 6, my understanding is that this just indicated the SEO's current salary, and therefore this would be the cost in future if he was retained. There was no commitment from me that he'd be retained post takeover at that salary.
No.
Now,
and I actually remember the very first meeting we ever had that of even buying this with the whole group at Unitas, that I mentioned to him that I wouldn't be paying him $13,000 a month. So that was in the very first meeting. I thought that they were overpaying him. He had just been made an SEO, I think, 1 or 2 months before or something like that. So he really didn't have the background of running a private equity fund.
Now, the position at this point in time is that you hadn't actually bought anything as yet, so you hadn't committed to anything, had you?
No.
All that's happened so far is that you've been sent the document we've just looked at, correct?
Yes.
And the second position I put to you is very simple. If you did buy the business, then the position with Mr. Gahlowt was straightforward. Unless you terminated him, or unless he agreed a salary reduction, then the business would remain liable to pay him $13,000 per calendar month. Isn't that correct?
Well, I'd have to explain the situation if that's okay. Can I explain?
You'll have the opportunity for that later. It's okay. The question I've put to it. So we can see in the audited accounts you're given in the same pack. So that's PDF 642. This is unusually for the 455-day period ended on the 31st of December 2019. And we see there that the salaries and other benefits stood at $1.7 million in that period. So you've talked about negotiations and about the situation, but I put it to you very simply that looking at these accounts and the ongoing expenses, a number of things are apparent. The first is that, given the fact the SEO is earning a lot less than $1.7 million a year, clearly there is a question mark, is there not, about what the status of previous employees is. Is that correct?
I don't remember this document, so I couldn't answer the question.
Okay. Well, if we go to PDF 673, and if we can go down the page, please. Let's keep going down, please. Keep going down, because I'm just trying to give the chain. Keep going down. Okay, go back up. Sorry. So that's the chain. That's the email. That's the email. The email on screen is the email we were just looking at of the 5th of April. If we then go up, this is an email from Al Safar.
And this is 5th of April, 2021, correct?
Yes, correct.
Okay,
And this
yeah.
email, that's why I wanted to put it in context. So the 6th of April, which is this email from Mr. Nadelsu, then says, second paragraph, we'd like to know how many employees well, it's missing letters, are currently under the company's visa. If none, have they been terminated and their dues paid? It's an obvious due diligence question, isn't it? Correct?
Yes.
And what he goes on to say in the third paragraph is that an undertaking has to be signed by the company's manager, director, stating that there are no pending legal issues. For such, kindly provide us the trade license along with the passport copy of the authorized person. And again, that is an obvious due diligence step, correct?
Yes.
And then if we go to the previous page, so upper page, sorry. Yeah, there we go. We'll see Mr. Aslam's reply. And so under, sorry. Oh, I've lost that now. Yeah, that's great. Can that be increased in size a little bit, please? Thank you. So it says undertaking. The undertaking referred to in your email will be signed by the director and UBO, Mr. Sanjeev Singhal. Please find attached his passport copy. And then it says on visas, all employees, save for the SEO, have been terminated and all dues have been settled. However, due to the pandemic, 6 employees remain on visa in order to provide them with the opportunity to arrange personal visas. Cancellation of all terms can be a term within the SPA. And if we go just up to the top of the page, please. We can see that this is, as I've mentioned, being sent by Mr. Aslam of Unitest, correct?
Yes.
And what's being said is, effectively, it's for you to bargain in the license agreement about what you want to do about these things, correct?
I'm sorry, could you repeat that?
What you're being, if we just go down slightly, sorry. It says here, when it says cancellation of all visas can be a term within the SPA, what you and your lawyer are being told here is that it's for you to bargain or not for what you want or don't want in the SPA, correct?
No, all employees were from my understanding of this, what we agreed on was that all employees, all visas, everything were to be eliminated. The moment I took over the company, any visas or any employees that were those contracts were terminated, and that's also in the SPA in a section that says that.
Well,
And the
let's
reason
go-
that the SEO had to be saved on there is because that was a deal that the SEO and the owner made, that he had to stay on there to do the handover while it was being handed over to me, to the new owner.
Well, you've referred to the SPA. Can we look at page 697 PDF, please? So this is your signature of the document, and we see that it's signed by Mr. Singh on the 17th of June. And the SPA, the first page is page 680 PDF. This is a legal document drafted by and negotiated between lawyers, correct?
Yes.
And it is this legal document which regulates the acquisition by you of the company and its license, correct?
Yes.
Now, at bundle 689, no, sorry, that's bundle 689, so try 694. No. Sorry. Sorry, it is 689 PDF. It was the Zoom. Can you zoom out, please? Thank you. Yes. So that's fine. Existing contracts of BTAML. So what it says is that the seller shall ensure and be responsible that at the closing date, all existing contracts of BTAML are either terminated or novated in favour of the purchaser prior to consulting with the purchaser, including but not limited to, and then point B, we have employment agreements, correct?
Yep.
Now, we see these brackets. The position is there's meant to be a consultation between seller and purchaser about what to do, not just about the employment contracts, but all of these types of contracts, correct?
Yes.
And then we turn on to the related issue of liabilities. If we could just go down one page. And this is clause 6.6G, which is just coming down at the bottom of the page now. And it says, bold type, capitals and underline, explaining that the purchaser is not liable for any costs pertaining to payments to any service providers or employees of BTAML, corresponding to any periods prior to the effective date, except mentioned in Annexure A. Now,
can I see Annexure A, please?
By all means, if you scroll down manually. It is blank.
Okay.
So if we go back to 689, we see that the reference there is, you see the words effective date on line 3 of this, and those words effective date are defined at PDF 682. Effective date means the date on which this share and license agreement is executed between the purchaser and the seller. So if we go back to 690, it's very clear from the last sentence of this. However, it is noted that all costs, whether specified or not, post the effective date will be to the account of the purchaser. It is, I put it to you, crystal clear that the liabilities are on you from that date. Do you agree?
No. The liabilities that were going to be on me out there to date were things that had to keep the corporation going in order for it to be transferred over to me, which was, if the license needed to be paid, they had enough money in the bank account, I believe, for the capital requirement. So things like that.
And I put it to you from, not least from the underlined bold black capitals and the detail of this clause, that it is obvious that this clause has been specifically negotiated. It's not just a standard form clause. This is a clause that has actually been negotiated between you and the seller, correct?
Well, yes, it is. But what I'm wondering is why there's no liabilities listed on the Annexure A.
Well, those are irrelevant because those relate to the position of before signature.
Yeah.
And if we look at those initials at the bottom of the page, that those are your initials, correct?
Yes.
So the position I put it to you is very straightforward. Any costs that had mounted up in the business between you getting this due diligence pack and you signing this agreement were costs to be paid by Mr. Singh, whereas costs after the signature of this agreement are costs for you, correct?
Roughly, yes, but not exactly.
Now, your evidence is, you and I need to take you here to paragraph, page PDF 314. No, sorry, it's not PDF 314. It is 299 PDF. Okay, hang on, this is slightly strange. Can you try 329, please? Sorry. Yeah, this is the one. So here we have, you say, well, can you just read that to yourself? The court will be able to read it as well.
I'm sorry?
If you just want to remind yourself of this here, because I'm going to ask you a question.
Are you talking about number 13?
Yes, correct. And it's the fourth line beginning, I did not believe, and I do not think that Mr. Single or Mr. Gahlowt believed that I was responsible for Mr. Gallowt's salary after June 2021. I
was not responsible for the salary. That's why there's several emails, I guess, that I've been privy to now of him asking for his salary from Mr. Singh. So what had happened is when I bought this company, I would not pay. I'm the one that spearheaded this whole thing. I would not pay Mr. Singh 1 cent until Amitesh was paid all his back dues, all his salaries, every cent that was owed to him. Until that was paid, then I would make the final payment to Mr. Singh for the company, and that's what happened. So I was not privy to how much money was back owed from Mr. Singh to Amitesh. Amitesh wasn't very clear that he was never being paid from him. I was also heard there was talks, I believe in the first meeting or second meeting, that Amitesh was maybe getting a finder's fee for finding someone who was buying this company. But the facts of the case are, and the truth of the case is I made sure that Amitesh was paid every single dime he was owed to him when I bought this company. And I would not make a payment to Mr. Singh until he was paid. And that's what happened.
Right. The question here, Mr. Vellucci, is this. When you say I did not believe, and I do not think that Mr. Singh or Mr. Gahlowt believed that I was responsible for Mr. Gallowt's salary, I put it to you that you have no reasonable grounds for that belief.
Yeah, we did. We had conversations about it. It wasn't in this spot. Do you want me to answer the question?
Yeah. Well, no, carry on.
Okay. So the truth is we had conversations about it in verbal conversations. So it was not in the spot, it was after that, because we realized, I don't know when we exactly realized that it was going to take more than 90 days. And so it was his responsibility to take care of Mr. Gahlowt's salary because Mr. Amitesh, I'll just call him Amitesh. Amitesh had to stay in the as an SEO position in order for the whole transfer to take place. So those two decided what was going to be, divvied up between them when the sale came through. I'm assuming.
And the position is that
if I don't buy the company, Amitesh gets no money. So I made sure that he was paid.
I'll wait for you to finish, Mr.
I'm done. Go ahead.
The position is that we have the SLA has resolved this issue in black and white terms. And what the SPA regulated, and that's why we went to the clause very carefully, was who was liable between you and Mr. Singhal to pay the salary. But your evidence into the court is that because you didn't read the document, then you were not bound to meet your legal obligations under the SPA. Is that correct?
Well, I don't even know if this SPA is, would even go to DFSA. Did you say DFSA or DIFC?
Because you did not read the SPA sale and license agreement, is it your evidence that you are not bound by that document?
I did read it when I signed it, obviously. But that was 3 years ago.
So then why do you say at paragraph 13 of your statement, at the time I did not closely read clause 6.6G of the SPA?
Well, I closely read it back then.
You did or you didn't closely read it back then?
I read it. I don't know if I closely read it, but I read it.
And you refer to your belief that your the transaction will be complete, and you refer to your belief about who would be paying salary. And the truth is that for you, this matter is not about what the legal documents say, not about what the law is. It's about what you decide to believe at any point in time. Correct?
Incorrect.
Now, I want to put the following things to you. First, this Sharon SPA, as we're going to call it, is the only example in this bundle of a clear written legal agreement to which you are a party. Do you agree or disagree with that?
Could you say that again, please? Sorry.
The SPA is the only example in this bundle of a clear written agreement to which you are a party. Do you agree or disagree with that?
Are you referring to just the SPA, or are you talking about in the entire process of me taking over the company?
The question is, it is the only clear written agreement in this entire trial bundle to which you are a party. Do you agree or disagree with that?
You're talking about a witness statement, or are you talking about the SPA?
I'm talking about the SPA.
Yes.
And second, that is a legal agreement which you did not honor, correct?
Incorrect.
You did not pay for the
I was the only one in this transaction with honor.
You did not pay for the ongoing liabilities of the company from June the 21st, 2021, did you?
It was only my responsibility to take care of the things that needed the company to keep going, which was DIFC licensing and things like that. That was a verbal agreement we talked about. It was not my responsibility to pay the SEO salary of $13,000 a month. That was the Mr. Singhal's responsibility. And Mr. Singhal did not fulfill that responsibility, and that is why I made sure that Amitesh got paid every single cent he was owed before I would pay Mr. Singhal the money to buy the company. And that's the facts.
Well, when you say the facts, going back to paragraph 13 of your statement, this is at page 329, we have it on screen. You talk about the basis of all of our conversations. And would you accept, Mr. Vellucci, that you are someone who does not like to commit to anything in writing?
I would say that I would have never, ever, ever in my entire life of 20 years of business ever had a labor dispute or not paid one of my employees, ever. If it was my responsibility to pay him, I would have paid him every month.
That the question was, would you agree that you are not someone who likes to commit things to writing?
Of course I commit things to writing. I'm a businessman.
So why are there no emails between you and Mr. Singh talking about the responsibilities for salary of Mr. Gahlowt?
I don't think I have any emails between me and Segal because I didn't deal with him. Mr. Amitesh dealt with him at all times, and that's the way he wanted it. So either Unitas talked with him or Amitesh talked to him. Amitesh was the point man. He said that I believe in the first meeting that Mr. Segal appointed him. He was to deal with the entire, deal. So he's the one that brought to the deal. He's the one that came to the office in the first initial meetings to talk about the deal. Mr. Sangil was not on Zoom call. I didn't have his contact information. So it was very clear that he was the point man that was going to handle this deal.
You're referring to discussions. So let's go through the facts then in order. After the SPA is concluded, you agree that the DFSA need to approve the change in control, correct?
I'm sorry, could you say that again, please?
After the SPA is concluded, the DFSA need to approve the change in control, correct?
Yes, that's true.
If we can go to first of all, paragraph. Let's stay as we're there. If you just go down a little bit on that page, there's a reference to a change of control application, which Unitas took in hand, correct?
Yes.
And then we see, can we go to PDF 714? So this is a DFSA application form. Go down a page to 717 PDF. And if we could just pause there, we see that this is a formal document, and you will see at paragraph 1, the declaration. I declare that to the best of my knowledge and belief, having made due inquiry, the information given in this form is complete and accurate. I understand it's an offence under Article 66 of the regulatory law to provide the DFSA any information which is false, misleading, or deceptive, or to conceal information where the concealment of such information is likely to mislead and mislead or deceive the DFSA. So you understand when signing this document that it is an important formal document, correct?
Yes.
And if we can go down, please, to PDF 725.
I'm sorry, this is my application, correct, to change the ownership?
Sorry, can we zoom back out just a tiny bit? And then if we just go up, you'll see
application. Okay.
Yeah, application forms and notices. And there we go, applications and notifications concerning a change in control. And then if we go, please, to PDF 725. Just to put this into context, can we just go up one page? So here we have the narrative. Oh, sorry, up one further page. So this is, it sets out your background, correct?
Yep.
Then we go down. So this is all about you. And then we get down to reason for change of control. There's someone at the DFSA is Tim Younger, who's aware of the situation. It explains the background in Mauritius, COVID, and so on. And then it says, okay,
I don't see anything here that says.
I unfortunately can't highlight the page. So it's where it says reason for the change of control.
But I don't see what you're saying about Mauritius that Tim Younger said here in print. Can you point that out?
Sorry, it says the DFSA, specifically Tim Younger, is aware of the situation with the authorised firm, Banyan Tree Asset Management, was part of a wider group and relied heavily on the income received from Banyan Tree Bank based in Mauritius. Please note the bank never had any direct ownership of the DIFC entity.
Okay.
During the start of COVID-19, it entered into financial difficulties. A conservator was appointed to try and salvage the bank from collapsing, and in doing so, the DIFC. However, the conservator thus far is unable to find a suitable buyer of the bank. That's the bank in Mauritius, correct?
Mm-hmm.
Notwithstanding the foregoing, the current UBO of Banyan Tree Bank Asset Management, Mr. Sanjeev Singh, was able to find a buyer for the DIFC entity. The bank has no authority over the DIFC entity and therefore is able to transfer his shares without any pre-approval from the conservator. And then it says timetable of proposed change as soon as possible upon DFSA approval. And then it says impact of the new controller. It will be positive because you have adequate financial resources and a very well diversified business in different jurisdictions. Financial liquidity, how you have reached the latest technology and network of key investors, help the business to sustain and create innovative products to offer in the region. Yeah, so that's the sales pitch. And then we move to the DFSA, and then we move down. You have the intention to.
Well, I wouldn't say it's a sales pitch. I'd say it's the truth.
Right. Would you agree that it was it also the truth, what you say here in the final paragraph? Keeping business continuity in mind, the new controller will retain the SEO, finance officer and compliance officer in order to ensure for a smooth transition of the processes. The new controller has also indicated a willingness to retain some of the previous employees of the DIFC entity to help relaunch the business. So that was also true, correct?
They wanted Amitesh to stay as a director for a few months after and remain as an SEO for a few months after while we did the transition. So yes, that's true.
Now the question was, is that true? Paragraph true or false?
Which part of it? Keeping business continuity in mind.
The paragraph as a whole, the one I just read. You explained that the other paragraph was true. Is this one true?
Subsequent compliance. Keeping business continuity in mind, the new controller will retain the SEO, finance officer, and compliance officer in order to ensure for a smooth transition of the process. The new controller has indicated willingness to retain some colleagues of DFC to help relaunch the business.
There's no reference here to retaining him for just a few months, is there?
Well, yeah, it says smooth transition of the process.
So where are the words "a few months" in that?
Well, I would say you don't need to put the words "a few months" in there if you're doing a business and you know what the transition process is. In most businesses, which is about 90 days to 6 months to transition buying a new business or buying a business that's been running for years. So, it's common sense.
Well, you say it's common sense, but it's not actually what the document says, is it?
Well, this is a smooth transition of the processes. So I take that as common sense. If you're buying a business that's been running, it's a normal 90-day to 6-month handover after you buy the business.
And let's look specifically at what you say. This is a PDF 329, paragraph 15. And so we've had the quote, and then it says, my intention was that Mr. Gahlowt would remain as the SEO for at least a few months because I was told the DFSA liked him and it would help with the application for change of control. However, and then we go into what you say it doesn't say. Simple question. You didn't tell the DFSA that you were only planning to retain Mr. Gahlowt for a few months, did you?
It wasn't a few months. It was over the transition of the process. So in common sense, when you're talking about businesses that are transitioning to a new owner, it's 90 days to 6 months.
That's and when we go down over the page here, 314 to 315, if we could be able to see both 314 and 315, that would be great. So up, thank you. Yes, so there we go. It says, however, this document did not indicate I was retaining him as an employee on the same terms. Well, you can read it yourself. That was never my intention, and I had communicated to Mr. Gahlowt that I would not be retaining him on the same terms. Now, this date must refer to the 16th of September 2021.
I'm sorry, you're saying this document is from when?
Okay, let's go back to PDF 725.
This is my witness statement, correct?
No, we're talking about the date of this document. So this is, if we go up, it will be dated on the first page.
This is the application to the FSA, correct?
Correct.
Okay. I think it just said June 7th, I believe.
No, there we go. There we go. Do you see those signatures? The 16th of September.
Date 16th of September 21. Yes, I see the dates, but I'm a little confused here. This is the application to DFSA, correct?
Correct. And paragraph
okay, and
15,
it's saying that on May 16th, 2021. Okay, I thought it was a little bit further along than that, like maybe 2022. But okay, if the document says that that's the date, that's the date.
And if we go back to where we were, which will be, my apologies, 329. Go up over the page. However, this document did not indicate I was retaining him as an employee. That was never my intention, and I had communicated to Mr. Gahlowt that I would not be retaining him on the same terms. And you're claiming that you had already communicated this to him, therefore, on the 16th of September 2021, before that date, correct?
Mr. Gontal was never an employee. He never came to the office. He never came to meetings. He never attended one board meeting. He never attended anything. So he was never an employee, ever. There's no employee that I've allowed to work out of the office, especially an SEO of a company. So after the takeover, he was a director with an SEO role while the transition was taking over. He was not an employee after that either. The employment contracts is the end of the day I took it over. So there's in my 20 years, I've never let anybody work remotely. And even most people that worked, two guys that worked remotely, they worked in my office for 3 years straight. My SEO has been in the office every day for 5 days, sometimes 6 days. Eddie Abramo since I hired him. So I do not allow people to work remote. I do not allow. I mean, how would you be an SEO of a company and working, or a CEO of a company and working remote? It's impossible.
Put it to you simply that.
And who would work for 2 years without getting paid if they were an employee? That's just common sense. And no one would work more than 2 months without getting paid if they were an employee.
Put it to you simply that by the 16th of September 2021 you had not said or confirmed anything of the sort to Mr. Gahlowt, had you? You had not told him that you would...
Told him what?
You had not told him that you would not be retaining him on the same terms, had you?
I'm sorry, could you repeat the question? And,
you had
repeat the date, please.
By the 16th of September 2021, you had not told Mr. Gahlowt that you would not be retaining him on the same terms.
Is that in my witness statement?
Could you answer the question to the best of your recollection?
I can't answer the question. I don't remember. That was 3 years ago.
So then why is it
can you repeat the question? Because you're trying to confuse me, so let's.
Mr. Vellucci, you've had the same question twice. It's a very simple question.
Please ask the question again.
Well, let me try asking it slightly differently. Do you agree that by the 16th of September 2021, you had not communicated to Mr. Gahlowt that you would not be retaining him on the same terms?
I think it was pretty clear the very first meeting that I was going to keep him on the same terms, because I told him in the first meeting he was, that wasn't a salary indicative of his background.
There is no indication in this bundle, apart from your say-so, that you ever communicated this to him.
Well, there
before
was
the 16th.
there was 4 people in there that heard it. So, that was Mr. Amitesh, that was Sagir, and that was Isaac, I believe, was in that meeting also.
Well, if you're
I
referring
mean,
to,
you're asking me to answer questions when I didn't own a company. I didn't
so
own
why
this.
did you
I didn't
include
own.
this? If you didn't know, or couldn't remember,
Can we just let the witness finish? Because it's very difficult to hear when you talk at the same time. So, Mr. Bellucci,
Your
why
Honor,
don't you finish your answer?
Your Honor, can we start with the question again? Because I'm lost. He's just yelling, and I'm just lost at why I don't understand the questions even you're trying to ask me.
I'll tell you what. Back to you, Dr. Bickford Smith. Maybe we go a little more slowly.
Yes, I'm mindful
Thank
of
you.
time.
I understand.
I do have to say I have asked the same question 3 times.
Let's try a final time and then perhaps we move on.
Do you accept, Mr. Bellucci, that by the 16th of September 2021, you had not communicated to Mr. Gahlowt that you would not be retaining him on the same terms?
I think it was very clear to Mr. Gato that I was not going to keep him on the same terms. Whether it was said verbally, I mean, in paperwork, no. Verbally, he understood that. That's why we had meetings later on, 2 years later, to talk about his role in the company. So he was very aware of this.
Why have
we thought this whole process would take 90 days. It ended up taking 18 months. So a lot of things in black and white were planned on for 90 days or 4 months. And so a lot of things were agreed verbally that weren't written down. So after 3 or 4 months, we're like, hey, this is going to take longer. Okay,
Your Honor, I'm just making sure the witness had the opportunity to finish.
Yes, go ahead. I'm done.
Put it to you simply that the true position is that you have no recollection at all of having said this to Mr. Gahlowt before
I
the 16th.
I know.
Could I be allowed to finish my question?
Yes, please? Go ahead. Sorry.
You have no recollection at all of having said this or communicated it in any way to Mr. Gahlowt before the 16th of September 2021, correct?
No, that is incorrect. As I stated before, in our very first meeting or second meeting, I stated that $13,000 seemed like a high amount of money for the position that he was in. He just had moved to the SEO position 2 months before. He had no background whatsoever of running a private equity company. He had no background of being an SEO. He had no background of a lot of things that they put him in position of about 2 months before I bought this. So yes, he was aware that I thought that he was being overpaid for that position.
And I put it
and
to you.
if someone tells you that you're probably being overpaid, you're being overpaid for your position, and they don't think you had the experience to actually do the job. One could use common sense and say, okay, well, obviously I'm gonna have to renegotiate my contract because this guy's telling me I'm already getting overpaid.
And in the course of one of your answers, you referred to a meeting with 4 people present. That's to say you, Mr. Gahlowt, Sagir Mohammed, and Mr. Aslam at you.
Yes, it could have been 4 or it could have been 3 of them. Either Sagir and Isaac were both in the meeting, or Sagir was in the meeting, or Isaac was in the meeting. I can't remember. It was a long time ago. I think 3 or 4 or 5 meetings at Unitas offices, and back in those days, in the early days of getting the SPA done. So either both of them were in that meeting, or one of them was, Segura or Isaac.
I put it to you that the meeting at Unitas in which you explained to Mr. Gahlowt that you considered that he was being paid too much was in October or November 2022.
No, it was in the very first meetings. It's one of the things I pointed out in the very first meetings. I'm a businessman. I look at every single thing as far as money wise, and I to see his background, and like I said right there. So my exact words are something like, "Wow, you were getting a good deal for this SEO position, based on the fact that you didn't you haven't had this position, you don't have the background for this position."
And when we look at bundle 756, sorry, can we try 721, please? Oh, I know which it is. It's 736. It must be 736. It's a typo. So we have here an email from the DFSA to Mr. Aslam. If we could increase the size of that, please. And this is the response to the change of control form. I wanted to inquire whether the new UBO proposes, in connection with the acquisition or change of control, to change the business model, business activities, or senior management of the firm, as this has not been made clear in the application submitted. I look forward to your response. Then we go to the previous page.
Was I CC'd in this email?
No.
Okay, so I couldn't answer any questions about it.
Well, Mr. Aslam here in his reply, I put it to you that he must have spoken to you, because in the second and third paragraphs, he says, our understanding from our meetings and conversation with the UBO is that there will be no change of business plan or activities for the foreseeable future. The UBO will retain authorized individuals such as the SEO, compliance and finance function as referenced.
Well, obviously, there's going to be a change in the business plan. They didn't have a business running. So I don't know. I couldn't tell you what this email is about between Isaac and Amitesh. I'm not buying a business the business made no money. It just lost money every year. So obviously, I'm not buying the business to continue losing money. They didn't use the business as a private equity firm in the UAE. They used it as a way to take people's money from the UAE and send it to the Bank of Mauritius. And the Bank of Mauritius went out of business because of bad investments.
So this is not an email between Amitesh and Mr. Aslam. It's an email from Mr. Aslam, do you see, to the person at the DFSA who had sent him the email. You see that at the top?
I can't tell you anything about this email. It did not come from me. Sorry.
So is your position that if the regulator is told something by Mr. Aslam, you're not responsible for that?
My position is that I'm not familiar with this email. I can't answer any questions about an email I'm not familiar with. I'm not CC'd on this email. This email wasn't between me and Isaac, or me and Amitesh, or me and Yai's Wami.
And we see if we could go to...
I think that what maybe was meant in this email, because I'm assuming, because he's compliance, is the compliance was going to say the same, which the compliance did say the same. We used Unisys for our compliance.
Yeah, but it's also clearly stated the SEO is going to say the same, isn't it?
I'm sorry?
It's also clearly stated the SEO is going to stay the same, isn't it?
This isn't from me. I couldn't answer that. What this email is about, what it's in context to it. Is it a follow-up email? I couldn't tell you. I mean, I can tell you that's what the sentence says.
And if we go, please, to PDF 802. This is an updated regulatory business plan. And if we go to 803, it sets out a number of things: the strategy and background, a strategy and rationale, the organizational structure, the management structure and governance, the proposed resources. Now,
Yes, I see it.
if we go down to page of the PDF, it is 821. What we see here is the board will consist of 2 executive directors and 1 non-executive director. The firm is currently in the process of interviewing candidates for the role. The senior executive officer will be a member of the board, and as set out in the figure below. And then we see the board is going to be you and Mr. Gahlowt, executive director and SEO, together with a non-executive director who has yet to be found, correct?
Yes.
And if we go down 1 page and a little, go down 1 page. We were on the right page just before. And just down within the page, please. So it says here, Amitesh Gahlowt will be appointed as an executive director and continue his role as SEO. He shall report to the board. Broadly, the SEO's primary responsibilities will include, and then there's a long list of things, correct? So,
yes, none of which these things actually happened. He didn't operate the operation. He didn't manage the overall operations and resources of BTML. He include making major corporate decisions. He never came to the office, acting as the main point of communication between the board and the corporations. That never happened. How could he do that if he was never in the office? Leading the development of BTL short and long term, he didn't do this. Oversight of the compliance and AML framework, including regular communication with the compliance, AML, finance, and risk teams. He did do some of that, creating and implementing BMTL's organization, vision, and mission. He had nothing to do with that. Evaluating the work of other senior managers of BTL. He had nothing to do with that. So yeah, these functions are set out of what an SEO would do, and Amitesh did not do any of these functions.
right, but you agree that those were the intentions as to what he would be doing as SEO, correct?
When we renegotiated his contract after the sale, yes. If we were to keep him as a, yeah.
And what actually happened is that before any of this gets signed off by the DFSA take the action that we can see at PDF 855. And what we see here, if we go down at paragraph 1, there's a proposal to withdraw the license.
I'm sorry, what date was this? Okay, I see.
It is dated
February
the 11th of February 2022. And can we look at paragraph 8 of this, please? Just going down. So we see a series of very damning findings by the DFSA. And can we look at one in particular, paragraph 8B1, the firm's inability to maintain systems and controls?
Well, I think this proves my point that the SEO wasn't doing their job even before I bought it. So yeah, it comes down to the fact that I believe that they didn't keep enough capital in the bank account, and so they were undercapitalized. They underwent undercapitalized many times, and I think that's why the DFSA started this notice, if I remember correctly. But um, Isaac would have more knowledge about this since he was compliance. But this is the gist of it is they kept taking their capital requirement under and under and under.
Mr. Bellucci, you can wait for counsel to ask the question before you answer.
I thought he was finished. Sorry.
Thanks.
And what they say here at 8B1 is they refer to the firm's inability to maintain systems and controls to ensure that, one, its affairs are managed effectively and responsibly by senior management, and two, it complies with all legislation that applies to the firm's financial services activities in the DIFC. And what I want to put to you is very simple. What the DFSA is doing here is going into chapter and verse about how there are a series of ineffective management systems and controls. Correct?
I wasn't owner of this company at this time, so you're asking me to answer questions. I was not privy to any paperwork of the company. I was not privy to any of what they were doing in the company until I bought the company.
But by now, from what I remember,
DFSA was going to take their license away because they kept going under capital requirements that you have to keep in the bank account to have a private equity fund.
And at C, we see the DFSA highlighting the firm's failure to deal with the DFSA in an open and cooperative manner and keep the DFSA promptly informed of significant events or anything else relating to the firm of which the DFSA would reasonably be expected to be notified. Correct?
Are you asking me to confirm what you just read? Yes, I confirm that you read something, but like I said, I had no idea. I'm not part of the company. I'm not the owner of the company. So how I read the situation is these guys did a bunch of foolery in Mauritius. Their bank got shut down, and it looks like they were doing some foolery again with this license that I didn't know about until actually I was taking over until I had the interview with the FSA, which told me that they had one strike against them already and that I need to run a very, very clean private equity fund because I'm going into this with one strike. And by that time, I was already through the process of 18 months. I said, okay, I'm willing to take that responsibility and I'll make sure that the capital requirement never goes under and I'll make sure the firm is ran the right way, which it has been since I've taken over. So I can't answer anything about why Banyan Tree was not running properly, why they almost lost their license. Amitesh was supposedly the SEO running this whole company, spearheaded the whole thing. And so why would they be losing their license? So I can't answer you. You know, I wasn't the owner at this time.
The point that I make is as follows. First, by this stage, you had signed the SPA. And so when you say you're not the owner, the position is that you are in the course of taking over this business, correct?
I cannot run the business. I do not own the business. It would be illegal for me to run the business, basically, you know, on a day-to-day operation. I don't own the business yet. So I had, you know, obviously the DFSA was threatening to take their license away for things that they were doing or probably not doing, you know, which is all the things they needed to do for compliance and being an SEO and things like that. But does that answer your question?
Yes, it does. So what we have when this notice lands, I'll try and simplify things for the sake of timing. The first is you are aggrieved to hear about this notice and the potential loss of the license, correct?
Yeah, can you go back up to the date of this license? This is, I think, the only time I heard about this, I believe, is when in my interview. Uh, I think if I remember correctly, it was in my interview with the DFSA, or maybe slightly after. I can't remember the dates, but I think this was I was aware of this. I think during my interview because Tim specifically said things that were, not done right with this company, and he listed a few things, and he asked me if I was going to be, the one to be responsible for it because it already had a strike against it, and I said yes, I'd take the responsibility for it. I understand it has a strike against it because they were undercapitalized and some tomfoolery they were doing in Mauritius, and so I can't tell you exactly when I found out this about, but I think this was when Tim Younger told me that, during the DFSA interview.
And the position is this: the change of control is not taking place, correct?
You mean is not taking, or is in the process?
By this date, self-evidently, the change of control application has not been approved by the DFSA.
I don't know if it was approved by this date, but I was not the owner yet. But I'd have to look back and see exactly what date I was approved. I believe that was 2023, August, I think. So, but yeah, I was not the owner of this company when this, obviously when this document came out on 11th February 2006. It says right there, Amitesh is the senior executive officer and Mr. Sanjeev is the licensed director.
And you knew that for as long as this change of control application was sitting with the DFSA unapproved, the business was continuing to incur costs, correct?
Well, I would say it was incurring incurred cost, but I paid the cost to make sure, not the capital requirement, but I paid the cost of the licensing of it. So if a license came up and need to be renewed, I covered that cost. So yes, it was incurring costs. If that's your question, of course, every business incurs costs every day, every month.
And one of those costs is Mr. Gahlowt's salary, correct?
I'm not sure when I was notified that Sanjeev, as I know him, Sanjeev was not paying him. I can't tell you what that date was. I know that he said he was behind payments at some point, I believe in an email or maybe verbally. So I couldn't tell you the exact date. Alls I know is, I mean, this says it all. The DFSA was going to take their license because they weren't doing their jobs, and they weren't running a business the way they were supposed to run a business in a regulated financial zone.
And the position is that the entity that has a liability to pay that paragraph, that salary, is the company, quite obviously, correct? The contract is with the company. It is an expense of the company, correct?
Yes.
And then there is a separate question about whether between you and Mr. Singh, who is going to pay this as between the two of you, correct?
No, I didn't have any conversations with Mr. Singh. It all went through Amitesh. The only time I think that I even had a conversation with him is in a Zoom call, the final payment.
To be clear, the question... Sorry, here I should apologize for the question. The question, sorry, was this. You knew, well, you were having a discussion via Mr. Gahlowt with Mr. Singh about who should be paying his salary, correct?
I don't think we ever even talked about that, to be honest. I don't know. His salary was not under my scope of work. That was verbally understood. That is why Amitesh always refers to Singhal as behind on his salary. He never says Mr. Vellucci is behind on my salary, ever. Not verbally or in an email, ever. And this guy This Mr. Sanjeev got in trouble in Mauritius. He was getting in trouble in the DIFC. He had a checkered past. And basically, he was not going to pay Amitesh one dime. He was going to pay him 1 cent on handover. I made sure that this man was paid everything that was due to him because I saw this guy and I saw his checker pass and I see the way he operates business, which is not operating business at all. It seems to me he's somewhat of a scammer, this Mr. Sanjeev. So I made sure Amitesh got paid every cent he was owed before I paid Mr. Sanjeev 1 cent because I saw the way this guy operates. So before I paid him, like I've said many times over, I made sure that Amitesh got paid every cent that was owed to him before I made my final payment to Mr. Sanjeev.
Page bundle page 315, which is PDF 330. And we go down to paragraph 19. You say, at one point during the change of control process, I recall a conversation with Mr. Gahlowt in which he told you that Mr. Singhal was behind on his salary payments. And he asked you if you were willing to split the cost 50-50 with Mr. Singhal. You felt a bit sorry for Mr. Gahlowt, so I told him I'd be willing to agree to that. But I needed to know that Mr. Singhal would pay 50% of the outstanding dues first. So that's your evidence, correct?
Yes, that's true.
I put it to you that the true position.
But I don't know what month that was or when that happened. I think what happened is both parties thought this was going to be a quick process. It wasn't a quick process. I don't know how many months Mr. Singhal paid Amitesh for. And at some point, Amitesh made a complaint that he was, that Mr. Segura didn't pay him for 1 month or something. I can't remember exactly. And he asked if I would cover 50% of the outstanding dues. Not outstanding dues, I would say of his salary going forward. But I need to know that Mr. Segura would pay 50% outstanding dues first. I don't know if I really knew how much he owed him at any point. I just know that he was behind on some payments, but it wasn't like, hey, he hasn't paid me in 6 months. It's like he paid me. Going forward, would you split it with Mr. Segal? And I said yes. And here it is right here that we can see that not everything's black and white. We can see that it was Mr. Singhal that was responsible for his salary. Amitesh knew that. Mr. Singhal knew that. I knew that. And that was the truth of the matter.
And the position here is this. Mr. Gahlowt has told you that he's not being paid. He's asked for whether you will pay, and he is in the position, do you accept, where you are saying, I am not going to pay your salary from June 2021 onwards because that liability should be on Mr. Singhal. And Mr. Singhal is saying to him, and via him is saying to you, that he's not prepared to pay his salary because as far as he's concerned, you should be paying it, correct?
Absolutely wrong. Absolutely wrong. I had no idea that Mr. Segal had months and months or whatever years of back salary. I did not find that out to the very end. I knew he was late on a few payments, and Amitesh had talked to me about paying 50% of his because I'm sure Sanjeev was like, okay, I paid this guy for 5-6 months. This is supposed to take 3-month process, just like I thought it would take a 3-month process, and it didn't. So at that point, I understood probably his frustration. I don't know what month this took place. I don't know how many months that he didn't pay him. I think he was late on a month or something like that. So I agreed, you know what, if he pays 50%, I'll pay 50%. I don't believe this is of the outstanding dues first. But let me read this, please. At one point during the change. I don't know if it was 50. If I would agree with my own statement here that says, but I needed to know that Mr. Segal would pay 50% of the outstanding dues first. I wasn't sure how much was outstanding. For all I remember is he was behind a month or something like that, and I believe the conversation was, look, this has went longer than we thought it would, which we both parties thought. And he's probably not paying me because it's 6 months past. And at that point, I agreed, okay, if he pays 50%, I'll pay 50%. So I remember that conversation. I can't tell you how much money it was. It was no bulk amount of money, that's for sure. It wasn't like he owes me $100,000 or he owes me $60,000. It was more of, hey, this has taken a long time to get to this change. Singal hasn't paid me in a month or a couple months or something like that. Would you be willing to pay 50% of my salary going forward? And I said yes. So this was a conversation that happened, but it's not exactly how this is written in black and white. I believe.
Do you agree that as we're talking about the drafting of this document, paragraph 20, which we are also at on page, you say here, for the purposes of drafting this witness statement, I've been shown an email. Yeah? Do you see that wording there on page 315 at the bottom? First line of paragraph 20?
I'm sorry, you're talking about for the purpose of drafting this witness state?
Yes.
Yeah, I see it. Number 20, yes, I see.
And then if we go down to paragraph 21, please. We say, I have also read the other email in this chain.
Could I see the email that we're referring to?
No, because
in 20?
No, because the point I want to put to you, Mr. Vellucci, quite simply, is that you did not see these emails at the time, correct?
I don't know which emails you're referring to. Can you show me the emails? Am I CC'd on the emails? I saw this email when I made the statement, but I didn't, I've also read the other email in this chain dated December in which Mr. Galanta was written that Galton has written that I said that I will not take anything on from April 21st. It was not discussed with him. However, I would need to see the emails we're referring to.
If you can go to page, if I'm going to do this as you want to, can we go to page 342, please? E is electronic 357, please. So this is the first of the emails referred to.
Okay, so I think this was showed to me during this case, correct?
Correct.
Yes, okay. Dear Sinchi was referenced to our discussion in my rumination yesterday, and this was in October 21. Good faith, I'd agree with you that all supports on March as we were thinking about giving up the license. We found party in that personal life.
I just want to focus you particularly on the last two paragraphs here.
Well, I need to read this thoroughly because just because Amitesh is saying I said something doesn't mean I said it. So I need to read it and be very clear. Just give me a moment. I'm sorry. The thing is that Amitesh liked to use different words for different people. And so, and sometimes he would say dues, Dues to me, I'm not familiar with the DEWS version. I don't know if this is a a DIFC version or if this is a UK version. Dues to me means dues. That means everything due to you. DUES. So I see here he's saying request you to please share your consent to share my remuneration 50-50 between you and Mr. Enzo. So he uses different words with different people. For me, he might say, hey, I haven't been paid for a month. I haven't, he didn't give me my salary last month. Is there any way going forward that you would split my salary with him for 50-50? Which at point I was willing to do that. But here it looks like he's sending an email, skewing it, saying that, oh, I didn't know he hadn't been paid until later on, until this case came. And so now he's saying that he was never paid by Sanjeev. I don't know why someone would work for somebody without getting paid if he was working for Sanjeev. And so I see that he likes to, mix his words with meaning different things with different people. So it looks like what he's trying to say here is the money that's owed to him would be 50-50 by me. That's absolutely incorrect. 100% wrong. When we agreed on this 50-50, it was going forward from the point that we had that conversation, which I could not tell you when we had that conversation. I can assume that I guess it was around this October 21, maybe, if he's got this in an email going to Sanjeev. But I can't be 100% on that.
The position here, Mr. Vellucci, is that you have just asked to read this email.
Yep.
You have read this email. You have given a long account of your views of this email.
Yep.
But can you agree with the following propositions? And can I ask you for yes or no answers to each of them?
Sure.
First, you were not copied into this email at the time. Yes or no?
Yes.
Second, it is correct that by this time, you had had conversations with Mr. Gahlowt in which he had told you that he was not being paid. Yes or no?
I can't answer that. I don't know what dates those conversations took place. Sorry.
And it is also the case that you were telling him that as far as you were concerned, responsibility for his payroll lay with Mr. Singh, correct?
Yes. It was always his responsibility. It was never mine.
And after a set of discussions, you have said, and this is in paragraph 19 of your witness statement, just to remind you of that is at 315 PDF 330. Paragraph 19. You have said, I told him a last line of 19. So I told him that I would be willing to agree to that, but I needed to know that Mr. Singh would pay 50% of the outstanding dues, correct?
Not outstanding dues. No.
So why are those words contained here?
I would say that basically it was the salary going forward. I didn't know that he owed him a bunch of money. I didn't know that until basically we closed this whole thing up. I knew he was late on some payments, which is what Amitesh told me. Amitesh never told me, hey, this guy hasn't paid me from day one. I still don't even know by reading this stuff when he didn't pay him from. I guess he didn't pay him since the day he made him an SEO. This was never told to us. It was never clear. None of this was clear. It was all all basically in conversations. And so I was never willing to pay 50% of that. Well, let's put it this way. Maybe if it was a month behind that Amitesh said, hey, I haven't been paid in a month. Would you cover 50% of that and cover 50% going forward? I might have said yes, but I can't, this was 3 years ago. I can't tell you what month we talked about this. I can't tell you. I know that there was no amount that we talked about. There was never anything discussed that, hey, Singh owes me $100,000. None of this stuff came up until basically closing of the company. And I mean, closing of the sale. So basically, when I found out all this stuff at the end, I made sure that Amitesh was paid all his dues, DEUES. Every single penny that was owed to him was paid to him. Him and Sanjeev agreed on an amount, because I think that Singhal probably told him, hey, I just won't close the deal. So they agreed on an amount, and I paid that amount. I made sure Amitesh was paid before I sent 1 cent to the old owner. That's exactly how everything went down. So we can slice it up every we want. We can show, this document, that was the deal. And in pretty much every document, even Amitesh's own emails, he knew I wasn't responsible for the salary. He knew it. That's why all his emails are to Sanjeev. That's why there's never one email say, hey, Enzo, you owe me $40,000 for not paying my salary. I've paid every employee for 20 years, and I've never not paid an employee money owed to them. And I've never been late on payments to employees. It's not my style. It's not the way I do business. So if I would have got an email that said, hey, I think you're responsible for this, and we need to talk about this money you owe me, then there would have been a discussion about it. That was never done. And that's why I made sure that Amitesh was paid everything he was owed when I bought this company.
Your Honor, I do need to raise a matter with you. I have been very carefully not speaking over the witness in view of Your Honor's earlier observation, with which I, of course, entirely agree. The problem I do need to flag is that we have had now a string of very long answers, which are not answers in many cases to the questions asked. Now, I am going to continue. I have, I'm afraid to say, got a very large amount of my case still to put to this witness, but what I have not been trying to do is to interrupt the witness or speak over them. But I do just need to be realistic with everyone today and say that if this continues at this rate, I think we will just finish Mr. Vellucci today, but the prospect of me being able to examine Mr. Aslam is very slim. I'm sorry to say that to Your Honour, and I don't want to be seen to hector or be difficult with the witness. It's obviously not my role, but I do need to flag that where we stand now is in a very serious difficulty of timing. I mean, as Your Honour can see, we are at paragraph 19 of Mr. Vellucci Enzo's statement. These are important paragraphs for the reasons that Your Honour is aware. We're about to head into a series of email chains on which great reliance is placed by the defendant. Now, I have to put my case to the witness, and I'm going to continue to do that, but I just need to mention the point on timing.
Right, yes. Mr. Vellucci, we have limited time for this trial. I fully understand that you wish to explain your position, but to make sure that we can proceed in as timely a fashion as possible, I would request, please, I think the questions that you're going to be asked are going to require, for the most part, a yes or no answer. It will be helpful, and I think we'll move more quickly if you're able to provide that answer. If you do feel you need to explain briefly after you've said yes or no, then please do so. But I think we're going to have to proceed in a manner, if possible, where if your answers could be more brief, I think we can finish more quickly, because we do have limited time both today and tomorrow. Is that clear?
Yeah, I'll try my best, Your Honor.
Thank you.
And,
that's much appreciated. Yes.
Sorry, could we take a restroom break?
Absolutely.
I'm happy to do that.
Yes, let's do that. Why don't we come back at, let me get my timings right. So 5 p.m. my time, which is, let's say in about 12 minutes, which I think in the UAE is at 1 p.m. Are we all clear?
Yes.
Yes.
And Your Honor,
yes.
I will be dialing out of the call because my window is not responsive, so I'm just going to turn it off, but I'll dial back in at then.
Certainly. And let's aim to try and progress more quickly when we get back, Mr. Vellucci.
Okay, thank you.
All right. Thank you
I'm
so
grateful.
much.
Okay.
Thank you. Wonderful. Let's recommence with cross-examination and let's try and proceed more speedily as was discussed before the break. Thank you. Over to you, Dr. Bickford-Smith.
You say at paragraph 25 of your statement, that's electronic 331. So one page down. Paragraph 25, if we could bring that up, please. It says the change of control was only approved on the 5th of July. There were a number of outstanding actions which needed to take place within a certain timescale before it was finalised. If we could go, please, to PDF 887. And going down, we see the DFSA letter. It begins by saying this change of control has been approved. It then goes down. We keep going down, please. And then it says, please note the following points. The firm is required to submit a withdrawal application of Mr. Singh. It's required to submit an application for you to join. Required to appoint and submit an application of its proposed licensed director as soon as possible. And then the final point, advised to maintain communication channels with the DFSA. First question, you've said in your witness statement there were a number of outstanding actions that needed to be taken. Do the ones that we've just looked at match up with your understanding at the time of the actions which needed to be taken?
There was a few other ones that aren't listed here. They wanted the name of the company needed to be changed. I don't see that one listed here.
Can we go down, please? Sorry, I think this may be a Zoom issue. Could we just go down? So here, so I think that the point that you're raising there is point number 1, financial. There's a requirement for a capital injection, correct?
No, they wanted the company name actually changed. So not Banyan Tree needed to be changed to a new company. That was one of the requirements.
But did you understand that there was a requirement that capital be infused into the business?
To meet the capital requirement?
It's point 1 on the bottom of the page we're looking at.
Yeah, I understand. Resolving capital and the EBCM reaches by injecting capital of USD 2 million as projected by the firm. Yes. When I
Next
took over.
page.
Yes. Mm-hmm.
And then we have some operational points. Point number 3, to move into a new office premises and notify the DFSA with details of the new address. Did you understand that to be a requirement at the time?
Yes.
And point number 5, to conduct a board meeting and provide copy of board meeting minutes, correct?
Yes.
Now, you say at paragraph 26 of your witness statement, this is at electronic 331, paragraph 26, which goes over the page. The DIFC needed to approve the transfer of shares. We needed to resolve the issue of Mr. Gahlowt's salary. Mr. Gahlowt had told me that Mr. Singh was behind on payments, and I wanted to make sure that I did not take over with a significant outstanding liability. And this takes us back to what we were discussing shortly ago. If we could go back up, please.
Okay, I'm sorry. Could I just read this
Yes.
real quick? Yeah, thanks. Okay, I read it.
And if we go back up to paragraph 20, for example, this is what we were discussing a moment ago before the break. Do you remember we went to look at this email?
Yes.
And if we go down, please. And then paragraph 22, you said you wanted proof he'd been paid before I transferred any funds. I suspected that if I paid 50% without that proof, Mr. Singhal would not pay his share, correct?
Well, these are completely different time dates, so I understand you're going these different numbers, but maybe the question so I can answer it because you showed me 3 different statements for 3 different time periods.
Well, I'm doing that because we've had a break, and I wanted you to be clear about what I was asking you. The question I want to ask you
Sure.
is this: do you agree that in all the conversations that were happening in 2022 until the meeting in Unitas in October, November 2022, the discussions that were going on between you and Mr. Gahlowt were about Mr. Singhal paying some of the money due to him and about you paying the rest of the money due to him? Do you agree with that or not?
Can you please state the question again?
Do you agree that the discussions that you were having in 2022 until the meeting that occurred in Unitas were about Mr. Singhal paying some of Mr. Gahlowt's salary and you paying the rest of it? Do you agree with that?
I do not agree with that. I mean, I've already explained it. I don't know if you want me to explain the whole thing again. I can do that. I'm sorry, Your Honor, but it's the only way I can explain the situation. I can't give exact dates. I can only say what happened, and that was that he asked me if I'd pay 50% of the salaries going forward because this other guy, Singhal, was behind a month or so. And I said if he paid 50%, then I would pay 50%. So you're kind of going up a year or two and going back a year or two, and so I'm just kind of shuffling all over the place. So no matter where we go or what we talk about, that's what happened. And the point is I made sure that that Amitesh was paid everything he was owed before I made any payment to the owner. So we can go here or there. You're just skipping years and stuff, but I mean it's the same. This is what happened, and I don't know how any other way to tell you that's how it happened.
Mr.
And when
Vellucci, your evidence is very clear, but I think we're going to have to be more brief. I do understand you want to explain your position, but I think we have that evidence clearly from what we heard from you from before the break, and I'm just getting a bit concerned about timing. So if your answer was no to the question,
Your Honor, but I don't understand his questions because he's going to different times in different space. This is my witness statement. Something has something to do with something else, and so I'm getting confused. I'm sorry. I'm really following. I'm hard. It's hard for me to follow his questioning in the way
Mr.
he's doing it.
The questions are straightforward questions about what you agreed. Now, if you disagree with the questions, you can say no and that you disagree with the proposition being put to you. But it is my job to put the proposition to you so that you have an opportunity to comment on it. Yeah. And so at paragraph 27, when we go down, I put it to you that when you're saying here that your position was that he needed to be fully paid before you paid anything, the position was and remained that Mr. Gahlowt was not saying to you at any point that Mr. Singhal would pay everything. Do you agree with that or do you not agree with that?
My position that Mr. Gahlowt needed to be fully paid before I paid Mr. Gahlowt. I think Mr. Gahlowt pushed back on it. I was then told Mr. Gahlowt. He Okay, what was the question again? I'm sorry.
Your Honor, I think I've asked the same question at least twice now.
I mean, I've
I
given the
think we're
only
going
answer
to
I
take
can
shortest
give.
questions. I'm sorry to
Yeah.
interject,
Yeah,
but
just
Dr. Bifford-Smith, if we could perhaps aim for shorter questions.
Yeah.
It's not a criticism, but just trying to see how we can cut through this and finish as
I'm
quickly as
happy.
possible.
I'm happy to do so. So the simple position is that the discussions with Mr. Gahlowt, you never said to Mr. Gahlowt that Mr. Singh would be paying him the entirety of what he, Mr. Gahlowt, was owed, did you?
in the discussion at the final table, let's call it the final discussion of the last payments. Is that your question? I'm sorry. I need a time frame of when you're
The word
referring to.
never is quite clear, isn't it, Mr. Vellucci?
Nothing. No, I'm sorry. Your questions aren't clear to me. Sorry. I don't know how to know that. I can only tell you what I know what happened, which is the same thing I'm telling you that at no point did I know that Mr. Sanjeev did not pay Amitesh money since the beginning of time. I never knew that until the end. And at the end, before it was closed, I made sure that Amitesh was paid every cent that he was owed by the company, the previous owner, before I made final payment to Mr. Sanjeev. Everything, every single thing that was owed to him. So
And
I don't know how to answer the
and I
question
put
here
it to you that
differently.
what you're saying doesn't make any sense, Mr. Vellucci, does it? Because
Well,
let's look at paragraph 30.
Sir, it makes sense because I'm telling the truth, and that's what happened.
Paragraph 30. You said, I had a conversation with Mr. Gahlowt where I told him I would not be paying him. You had not had that conversation at this point in September, October 22, had you?
I'm sorry, what?
You had not told him by September, October 22 that you would not be paying him $13,000 a month, had you?
I wasn't paying him $13,000 a month. You
And
can
when
see
you
in all his emails, he's talking to Sanjeev. He's not talking to me. He's never asked me for any salary. He told me that he was behind a payment or two, Mr. Sanjeev, and asked if I would pay 50% going ahead because if I remember the conversation, because we had many conversations, because this deal took 18 months. It was supposed to take 3 months. I don't know how many months went by. I don't know if a year went by. I don't know what date we had that conversation. He said that he was behind in a couple payments. He was probably, angry or didn't want to pay Amitesh because it was taking too long. And I agreed at that point. I said, listen, if going forward, if he's paying 50%, I'm paying 50%. I never heard back from him about this. And then at the end, there was a big bill owed to Amitesh, and I made sure that he was paid all that money that he was paid. Him and Sanjeev said they were going to talk about it after our meeting. Everybody was there. They went and talked about it. They came back with a figure. That figure was everything that Amitesh was owed. We paid him that money, and then I sent Sanjeev the money to the rest of the money that I owed him for minus what he owed Amitesh. That's what happened.
Paragraph 30, second sentence, you say, I made sure that Mr. Gahlowt's employment contract ended on the day that the transaction completed. That is false, is it not?
It's not false. That's in the SPA, that the employment contracts are automatically over when I take over the business.
How did you make sure that his employment contract ended on the day that the transaction completed?
Because that was stated in the SPA.
Did you tell Mr. Gahlowt that his employment was ended?
Well, he was never. I don't know what you mean by employment. He was never. He was never an employee. In my opinion, Mr. Amitesh was never an employee.
And
I didn't even consider him an employee before that. I mean,
and the SPA does not say that the employment contracts are to be terminated. It says the following: first, that it is the seller's responsibility to do this, And second, that there should be consultations between you and the seller beforehand, correct? We looked at that document earlier.
It was very aware that his services were not going to continue after the transition period. And that was clear in January. So I had made him an offer for an employment. He turned it down. And that's when we parted ways. And that's when this lawsuit came that said that we owed him all this back money.
But that was on your evidence, that was in January 2023, wasn't it?
Yeah, I mean, there might have been some talks before that, but the January I remember the specific talk in January. But we might have mentioned something, I don't know, December, November. But in January is where it got, the wheels hit the rubber.
One of the reasons why the court can be sure that you didn't make sure that his employment contract ended on the day that the transaction completed is that he was never sent then a notice of termination, was he?
Well, he wasn't an employee. So he was a director.
That again was later, wasn't it, Mr. Vellucci?
I'd have to look at the dates. I can't tell you exactly when that happened.
Another reason why the court can be sure this didn't happen is that we've already seen the letters to the DFSA and the email making clear that he is going to be retained, correct?
He would be retained over the transition period. It was a requirement of DFSA. They wanted him to be a director during the transition period, which we gave him. We made him a director during the transition period. Transition period to me is 3 months to 6 months transition period. Usually when you're buying a business that's operating.
And what has happened at paragraph 28, if we just go up a little bit, is you say, for the purposes of preparing this witness statement, I have been shown an email. Again, this is not an email that you were sent at the time, is it?
I would have to see the email.
Okay, well, let's go then to 897.
If I'm not CC'd in the email, then of course I didn't see it.
Sorry, it's 897. It will be 913. We go up. Up. So we can see the people here in copy are Mr. Azar, Mr. Gahlowt, Mr. Ali, and Mr. Aslam. You are not in copy to this email, are you?
No, I'm not.
And so if we go back to 318, which is I think 331 or 333. No, it's one page further down. Sorry, one page up. And you say at paragraph 29, the contents are consistent with my belief at the time. Can I just put this to you very simply, Mr. Vellucci? What has happened here?
Well, I didn't get to read the contents of this email was consistent with my belief at the time. Could I read the email that you just showed? I mean, what exactly are you asking?
Mr. Vellucci, what I want to put to you is a broader point, which emerges from the fact that you want to look at this email. What has happened here is that in the course of preparing your witness evidence, documents have been gone over, and you have tailored your evidence around those documents. Do you agree that?
Of course not. Everything in my witness statement is, from my point of view, is the truth. I've probably been shown some documents and asked to answer those documents, but that wasn't preview to before, I assume. But I've already told the truth, exactly what happened.
And
he was paid every penny that he was owed, and I made sure that happened. I made sure that he got paid every penny he owed before I paid the owner. And that is empirical, the truth. So we can go here, we can go there, we can do this, we can do that. But that's what happened. I made sure this man got paid every penny he was owed from this old owner and this old company. They were up to no good, I didn't trust them.
I'm sorry to interrupt. Ms. Fucci, I know you feel very strongly about this point, and we've heard it a few times. We've taken on board your evidence, but again, I'm concerned that we need to get through this and we need to finish it today, and we also have another witness. So I'm going to ask you to please try and answer yes or no. If you don't agree with something, say no. And I'm going to ask you, Dr. Bitford-Smith, questions as short and simple as possible, please. And if somebody is not copied on an email, let's just take it as given. And let's try and get through this quickly. Right.
I only went to the document, Your Honour, because the witness asked to go there.
I understand.
Again,
I understand.
Putting it simply, Mr.
Can I ask the judge something, please? Your Honor, I'm not trying to take a lot of time on purpose. It's just that sometimes it's not a simple yes or no. So I feel if I say no, then I'm not telling the truth, because there's more to it than saying yes or no. So I'm not sure what to do.
I do understand, but just please try and be brief. And if you've shared the point already, I do understand that you feel very strongly about the point that you wanted to make sure that payment was made to the claimant in November 2022 before you paid Mr. Singhal. We've got that point. So please try and be brief and limit the explanation. Thank you.
Okay.
And simple question. If you didn't see an email at the time, you can't have relied on it in your actions, can you? Simple point. Yes or no?
Well, it might have been something that was said verbally. So I might not have saw the email, but what was discussed in the email might have been discussed with me verbally or for something. So I would say it's not as simple as yes or no.
Paragraph 31 here, you refer to a spreadsheet. You say, I don't recall being sent it. Looking at it now, you can see this. These are your analyses of the document today, correct?
Well, yes, and if you'd like to know what the truth is in the story, is that we all agreed that Amitesh gave us a final amount that he needs to be paid for everything. We paid that. He was still dealing with the accountant. He was still giving stuff to the accountant. So when we explained all this, how it was going to break down, he did the spreadsheet. I don't think I was privy to the spreadsheet. I'm not sure about that. It was given to the accountant. It was given to the accountant in a way that was left kind of ambiguous, so that later on he could claim there was some monies. I believe now, since this lawsuit, that he could put some wiggle room in there and say, oh, well, I wasn't paid this. But it was very clear that he was paid every single thing that was owed to him up to that day. So his stuff in his spreadsheet, and then the things that there was a lot of stuff that didn't add up with stuff in emails versus what was put in the Excel sheet and what he was telling the accountant. So he was like, kind of like at that point, I don't think I was complete owner. So he was a one-man operation. He could do whatever he wanted to with no oversight.
You were never told by Mr. Gahlowt that his agreement with Mr. Singhal would include all the amounts that he was owed.
I'm sorry, repeat the question.
You were never told by Mr. Gahlowt that his agreement with Mr. Singhal would include all the amounts he was owed.
Oh, 100%. 100% that was agreed in the last meeting. 100%. Every single thing he was owed. Dues, salaries, everything was all in that lump sum that was paid to him. I would have never paid the owner any money until all that was agreed upon.
And you've referred on several occasions to a meeting. This was a meeting at Unitas's office with Mr. Gahlowt, two representatives of Unitas and you, correct?
Yes, sir.
And what had happened at that meeting was the following. First, going into the meeting, there was discussion about completing the transaction. Do you agree with that?
Yes.
Second, do you agree that one thing that needed to be done was for Mr. Singhal to receive his payout from the company, correct?
Yes.
Third, do you agree that one thing that needed to be done was to execute the various corporate documents, resolutions, and so on, correct?
I'm not sure if it was supposed to be done at that meeting, but the meeting was to talk about that. Yes.
We agree on that.
Yes.
Next point. By now, the major point was Mr. Gahlowt's outstanding salary. Do you agree with that?
I wouldn't use the word salary. I would say the amount that was owed to him that was, a big shock to us. I'm not sure what date we found out exactly how much money he was owed. I think, and I could be wrong, I think it was in that meeting that we found out how much money was owed to him.
Again, we agree on that largely.
Yeah. Well, I'm just saying.
Or certainly we agree that you may have found out then. So
yeah.
What happens at this meeting, I put it to you, is this. You do at that meeting say to Mr. Gahlowt that going forward, you would not be prepared to pay him $13,000 a month. Do you remember saying that?
Yes.
And do you remember him raising two issues? First, his salary level, and secondly, his past dues.
I don't remember him talking about his past dues. I remember him telling me how much an SEO was making in the DIFC at the time. And I remember telling him that is a SEO with 20 years experience in private equity funds and running, these sort of financial businesses. And he didn't have that background.
And do you agree that at that meeting he said to you, okay, if that, or words to the effect, let me rephrase it. Do you agree that at the meeting he said that if this was your position, he would not proceed with his application to be a director and would resign? Do you agree with that?
I'm sorry, could you repeat the question?
Do you agree that at that meeting he said that if you were taking that position, he would not continue with his application to be a licensed director and would resign?
I want to be clear about what meeting we're talking about. We're talking about the meeting with the four of us when we're closing the deal, correct?
Correct.
No, this was not discussed at all. The only thing that was discussed on that meeting was closing the deal. And so Amitesh, I don't think would throw any rocks into it, considering I was forcing the old owner to pay him all the money he was owed. So I don't remember in that meeting any discussion about, I remember us discussing his SEO role in a meeting and me telling I didn't think his background justified $13,000 a month. I don't know if it was in that closing meeting. That closing meeting was basically all about what was needed to be done at the close, which was me, and I believe Sanjeev he was definitely in contact with Amitesh for the whole meeting. I think Sanjeev might have been on a Zoom call in the meeting. I'm not sure. And the whole purpose of that meeting was to get to the bottom of the last thing that needed to be done, which was to pay Amitesh. So I don't believe that we discussed Amitesh's those kinds of things. We did discuss that in a meeting at Unitas. I'm not sure if it was that closing meeting, but that particular meeting was specifically just about getting the ball across the goal line, and that was that Sanjeev was going to have to agree to pay him everything, and Sanjeev pushed back. He did not want to pay him. He said, "Yeah, okay, no problem. You guys send me my money, then I'll pay Amitesh." Like, no. It's not going to go like that. The company's going to pay.
He wasn't at that meeting, was he?
No, but he was talking between Amitesh. So they were literally on the phone talking sometimes. And I believe Amitesh even stepped out of the room to talk to him. And he was in contact with, Sagir and Isaac during this meeting, I think either by phone. He could have been on Zoom. I can't remember. But the whole purpose of that meeting was to make sure that Amitesh got paid all his money and that there was still money in the bank for the capital requirement, which would go to Sanjeev because that was his money. It wasn't my money. I would have to reimburse the bank account for a capital requirement. So I'm not sure what transpired first. I put the money in the bank and then it was paid to Amitesh and then Sanjeev was paid. But that's basically what that meeting was about, was getting Amitesh paid all the money he owed, and then just sealing up, in what order that was all going to take place.
And what happens at this stage when Mr. Gahlowt says he's going to resign is
He
that
didn't. He never said he was going to. Sir, he never said he was going to resign at the closing meeting.
Sagir says this will look very bad with the DFSA. That's the first thing he says, correct?
Incorrect. I'm not sure which meeting you're talking about. That might have been said at a meeting, but it wasn't at the closing meal when we were talking about paying the owner. We've already been approved by DFSA. We're already past that stage. We're now paying the money out. So you might be referring to another meeting that is not the meeting I'm talking about right now. Sorry.
And the second thing he says is a basic one. We've nearly completed this transaction. Let's resolve this issue and carry on. Do you agree with that or not?
Okay. Now, I think that this could have took place in that meeting because Amitesh and Sanjeev got into an internal fight. So they got an internal fight within themselves because I think Amitesh was asking for a certain amount of money. Sanjeev didn't want to pay that certain amount of money. They came up to a settlement of what that amount was going to be, and that's what I paid. So that could have taken place in that meeting, yes. So now that you've changed the context in the second question, I kind of understand it better now. I remember it better now. And so I think what happened is, if I can tell you what I think what happened is that basically Sanjeev said he wouldn't pay the money, and then Amitesh said, "Okay, well I'm going to resign." I think, if I can remember correctly, and then Unitas was kind of the neutral party. They straightened it out. Sanjeev and him went behind the scene. They agreed on an amount to get everything paid out. I paid all that money out, and I paid out Sanjeev. So that conversation could have took place at the closing argument. But to be honest with you, I can't tell you for 100% that was at that meeting or a different meeting.
And you then up your offer to Mr. Gahlowt in regards to salary to $10,000. Do you agree with that?
No, I don't agree with that. I talked to Mr. Gahlowt about a $10,000 salary. I don't know if it was at that meeting.
And he did not agree with that proposal, correct?
Well, I don't remember giving that proposal. And then, I mean, obviously the deal went through. So I don't even think that even happened, to be honest, like that.
But what is understood in the meeting with the four of you is that discussions were going to continue between you and Mr. Gahlowt about his future salary. Point number one.
Yes, that's true.
Point number two, that in the meanwhile, he was on his existing salary, correct?
No. If this is the closing meeting, he wasn't on a salary. All his dues and everything was paid to him. It was going to be a new contract that we talked about. And I believe the next time we talked about it was in January. I made a proposal of $10,000 a month. He said he would think about it. He came back in March and said no, because I told him it wasn't, I told him the $10,000 a month, what I expected of him, what his job description would be, which was, bringing in funds into the certain amount of money into the funds and things like this. I had a whole list of things that he was going to be required for him to do. And so in March, he decided not to accept it. And I believe March or April is when he sent his resignation as a director / SEO.
And can we now please go to PDF 317? Now, this is Mr. Aslam's witness statement. I need to just be clear with you. I'm not putting it to you as the claimant's case, but it is my role to put this to you. Mm-hmm. What we can see here in the first sentence is that he can remember a conversation between you and Mr. Gahlowt at Unitas's offices around October or November. Mr. Sagir Mohammed is also there. And I put it to you that, first of all, Mr. Aslam is correct to say that you discussed Mr. Gahlowt being the SEO going forward. Do you agree with that?
I would say director. Director with the SEO role. Yeah, I mean, could you ask the question one more time, please?
I'm simply putting the third sentence to you.
Yes, okay.
Do you agree with that or not?
Oh, well, let me read it. I understand that this would take effect from the point when the deal was finalized, i.e. early November 20th. Okay, I can recall the conversation. My boss, thank you. Yeah, that sounds about right. He was going to be in the transition phase of 3 months. This was something the DFSA wanted. Yeah, yes.
Now, his recollection was that there was an agreement to $10,000 a month. We do not agree with that, but we do say that this figure was discussed at this meeting. So do you agree or not agree that this figure was discussed at this meeting?
I think if I recall correctly, basically what had happened was a standoff between Sanjeev and Amitesh. And so they came to an agreement on the amount of money that would owe to him. We came to an agreement if we were going to keep him on, what that would be. So I think this is pretty accurate, which is 30,000 dirham is around $9,000 a month, I think. So that seems about right.
And also, do you agree that in the same, so this is 4 lines from the bottom, in the same meeting, Mr. Gahlowt was speaking about his previous dues. Do you agree that he spoke about his previous dues in the meeting?
I just want to clarify, can we, I see DUES. DUS to me means everything. So if someone says, I'm due something, it means they're due everything. I just want to make sure we're clear on that word. Is that your understanding of the word?
We're again in agreement on that.
Okay.
So do you agree that Mr. Gahlowt was talking about his previous dues in that meeting?
Yes, I do. Everything was owed to him.
And do you agree that in that meeting you said, I'm not responsible for these and they should be finalized with Mr. Singh, correct?
Well, no, that's not accurate. I was made sure he was paid everything he owed by the company before I made the payment to Mr. Sanjeev.
Okay, well, just to be clear about this important point, we agree that by this point, Mr. Singhal and Mr. Gahlowt have reached a number, correct?
Well, I can't tell you exactly what time in the meeting they came to a number, to be honest. But yes, we came. I don't know if we came to a number that day, to be honest.
No,
I'm
saying is that already before this meeting, the two of them had reached a number and you had seen that number in an email sent in October.
I'm not positive about that. And
I believe what Mr. Gahlowt said in the meeting was, there are other dues owed to me. And what you said in that meeting is, I am not going to pay those dues. Do you agree with that or not?
I do not agree with that.
And do you agree that the question was not resolved at that meeting?
I can't answer that. I can't remember. I just know that we discussed the figure that was owed to him, and him and Sanjeev talked and came with a different number. If I remember correctly, they came back with another number maybe 1 day later, maybe 2 days later. It could have been the same day. Alls I know is that I only paid Sanjeev when Mr. Amitesh was paid everything that was owed to him. They decided on that number. I paid that amount of money to Mr. Amitesh, and then I paid the remaining balance to Mr. Sanjeev. So,
And it is not true that Mr. Gahlowt was in the meeting speaking to Sanjeev, because all of his discussions with Sanjeev had already occurred by this point, hadn't they?
Oh no, he was on the phone with Mr. Sanjeev that day in that meeting. He actually stepped out of the conference room to talk to Mr. Sanjeev.
Well, I put it to you, that is simply wrong.
Well, how could we have a meeting with the handover with the owner, at the very end? I know that Amitesh spearheaded the whole thing, but how could he not have a conversation with Sanjeev? And once again, this could have been a meeting after that, or it could have been a meeting before that. But he definitely stepped out of the conference room to talk to Sanjeev. Now that I'm pretty sure that was in this meeting, but it could have been a meeting after that. To be honest with you, I can't even remember exactly how many meetings we had for this closing thing. I believe 2.
If we could go to electronic 900, please. Before this meeting, you have received this email from Mr. Gahlowt.
Okay, let's see. Well, it just says to Enzo Vintage Loop. I don't see my email address. Okay. I have shared the working of the cash flow with Sanjeev. This was the given for the could go down. And then, I'm sorry, what was the question?
That you had received this email before the meeting we're talking about.
Yeah, it looks like it. It looks like it received on 17th. What can you remind me what date the meeting was? At the final meeting at the office?
In November 22.
November 22. Okay, that sounds about right. November 22. Yeah, okay. My due's till 5th July. Yeah. My due's till 5th of July 2022. We paid by Sanjeev. After that, we paid by you as you are the approved. Keep going down. Did I answer this email? I don't know if I received this email. I didn't answer this email. All I know is all the money that was owed to him that I made sure that he got was paid. Every penny.
And if we look at this email, just going up, please. Just down a little bit, please. So we have a calculation being given for how much is being paid. And do you see underneath the table, he says to you, the above amounts are deducting my dues that will be paid by Sanjeev, correct?
Fund flow.
And he isn't saying to you that Sanjeev is paying all of his dues, is he?
Sanjeev owed him all his money, and I did not pay Mr. Sanjeev a penny until all that money was paid to Amitesh. It was very clear. All parties understood it. All parties knew it. Amitesh actually stopped the deal with Sanjeev because if he wasn't getting paid, he wouldn't let the deal go through. He would say,
And
"Oh, well, I'm not going to do anything until I'm paid, X amount of money." And I would have said, "No problem." But that money will be paid out of the money that's going to Sanjeev. And that's what happened. And they negotiated a price, amount of money that covered all his dues. And I paid Amitesh all that money that was owed to him. And then I paid the owner the rest of the money that was owed to him. So
if we go,
that's what happened. That's all I can tell you that happened. We can go back and forth over this, that, or another document that Amitesh, did by himself in the Excel sheet. But that's what happened. Amitesh agreed to that. Sanjeev agreed to that. I agreed to that. I made sure the man was paid all his money, and I paid the owner his money.
page 961 electronic. Sorry, 951, my apologies. No, no, it should be. Yeah, here you go. So this is a document. If we blow this up, yeah. This is a document that you refer to, but you didn't see it at the time, correct?
I'm not sure if this is the document I'm referred to. I just know that there was a document that circulated. I'm not sure if it was an Excel sheet. I can't remember. It was just the amount of money, and Sanjeev said he wasn't going to pay it. And I said, I'm not paying you until it's paid. They negotiated on an amount of money that would be paid to pay everything that Amitesh was paid. I made sure Amitesh was paid all that money, and then I paid the owner. That's all I can tell you.
If we go to 962 to 963, we have an email. This is PDF 962 to 963. We have an email going over the page. But my simple point to you about this email is that this is not an email you were sent or saw at the time. It's part of a back and forward between Sanjeev and Amitesh, which you were not involved in directly, correct?
If I'm not CC'd on the email, yes, I did not receive the email at the time.
And if we go up to 946, please. We see Sanjeev chasing for payment, correct?
What do you mean? I'm sorry. What do you mean by chasing the payment?
Based on trust, I provided all documents and process. Please shepherd the processes so that the funds reach me without having to chase anyone. And this is on the 3rd of November, correct? You can see it from the email.
We don't have this email.
It's turned the wrong way.
No, sorry. This should be bundle 9 PDF 961. Yeah. Sorry, this may explain it. Sorry, I was on my copy. If we go down a little bit. Email of the 3rd of November. Up.
Can I read the email?
Yes.
Are you just asking me if I got the email, or do you want me to answer a question in the email?
Well, okay, I want to ask you this question. Do you agree that by the time of this email, Sanjeev was chasing for payment to be made to him?
I don't know what the email's in context to. If I just read it, it looks like to me that, Dear Amitesh, please proceed. Dear Isaac, as discussed and agreed, I request that you have oversight over this process. I'm not sure what is discussed and agreed, so I don't know what this email pertains to. Based on trust, I provided all documents and assistance. Please shepherd the process so that the funds reach me without me having to chase anyone. Do you want me to assume what this email's about? Is that the question?
No, I'm putting it to you for the context, which is this. First of all, these are emails you refer to in your witness statement. That's one reason I'm going to them. The second reason is the context here, by the time of this meeting in November, is that Mr. Gahlowt and Sanjeev have reached an agreement on the number. Mr. Sanjeev Singh is chasing for payment. And it is in that context that you meet at the Unitas office to complete the transaction, correct?
I don't think so, because he wouldn't have to chase for the payment, because Amitesh is the one that I didn't have access to the bank account. So Amitesh is the only one that could pay him out. So I'm not sure where this time frame is.
The position is that at the Unitas meeting, when you and Mr. Gahlowt have your discussion about his salary and his past salary, yeah, you have a choice, don't you? Your choice is, do you do a deal with Mr. Gahlowt, or do you not do a deal with Mr. Gahlowt? That was the choice you were faced with in that meeting, correct?
Absolutely incorrect. The meeting was between Sanjeev agreeing to pay Mr. Amitesh all his back money, or I was not going to go through in the deal. I fought for Amitesh to get every penny that was owed to him, and I made sure he got all the money that was owed to him. That's what that meeting was about. And there might have been other things. There might have been other things discussed in that meeting, but that's basically what that meeting was about. It was for Amitesh to get paid everything he was owed by Sanjeev, and I made sure that happened. So,
and if we go to bundle 335, PDF 335, and you say, if I had known of this, that he would try to saddle you with a debt, the negotiation would have looked very different. I would, of course, not have made the final payment due under the SLA unless Mr. Singh had agreed to pay all of the money to Mr. Gahlowt. I put it to you simply that you made the final payment under the SPA, despite knowing that there was an outstanding disagreement between you and Mr. Gahlowt about his salary.
Absolutely not. I made sure Amitesh was paid all his money, every single penny, before I made final payment. So at the time of that final payment to Amitesh, there was absolutely not one dirham owed to Amitesh. And I did not make final payment to, give authorization to make final payment, which I believe Amitesh sent to the owner, until he was paid in full. He was paid in full. That's it. He was paid in full to that day.
You never sought a written confirmation from Mr. Gahlowt that he had been paid all his dues, correct?
I didn't need to. It's in the bank statement.
You didn't.
There's money transferred to him, a bulk of money.
You didn't execute any form of agreement with Mr. Singh about this either, did you?
I don't believe so. I don't think so. Maybe I don't know. Maybe maybe it's in an email, but not from me. Maybe from Unitas. I mean, he wasn't getting paid until he paid Amitesh. It's as simple as that. So until Amitesh was paid in full, he was not getting a final payment. So if he would have never paid Amitesh in full, there would have been no deal. The deal would have dropped right then and right there. If Amitesh would have said, "Hey, listen, I actually am owed what is it saying, $300,000 or whatever," he would have said. I said, "Okay, that's coming out of the last payment." Of course, I would have said that. Guys, I mean, I fought for this guy to get every penny that was owed to him. I'm the one that stopped the deal from going through to get this man paid every cent that was owed to him. He was paid every cent that was owed to him, and then I paid the owner the final payment. I mean, that's the facts.
You've said that you're an experienced businessman and you do things in writing. There is nothing in writing from you to Mr. Gahlowt saying this is the deal we've reached, is there?
Well, I'm a man of honor. So I don't think we need to write a contract, because saying that he's going to get paid when the owner can't get paid until Amitesh is fully paid. He's not, I'm not buying a business. Amitesh isn't a business.
And as far as you were concerned, again, focused here, you said, I would, of course, not have made the final payment due under the SLA. Well, put it to you very simply that if the SPA didn't conclude, the company would be wound up. Do you agree with that or not?
Yes, I agree with that.
And do you agree that a consequence of it being wound up is that all the capital you had infused into the business over the previous period since the SPA would be lost, correct?
Yes, of course. Yes.
So the reason you chose to go ahead was because you needed the transaction to complete, correct?
What do you mean by that? I don't understand
Well,
the question.
let put it another way. You knew that if the transaction didn't complete, you'd be losing all your money, correct?
Yes.
And your assessment was that Mr. Gahlowt carrying on as SEO was important for the DFSA, correct?
I would say yes. I would say it was important to the DFSA for the transition period. Yes.
And that was
But there was more. It was
why-
a director role more than the SEO role.
Now, on this director role, the distinction you have drawn between a director and an SEO is wrong, isn't it? Because he was both director and SEO, correct?
No. Well, I would say that he was a director and he was acting as an SEO while the transition took over when we took over the company. Before
And
that,
you agree,
I can't really tell you what his role was.
you
what his
agree
role
that
was
he
in the
was an
company.
executive director. There's no suggestion that he was a non-executive director, is there?
He was an executive director. Yes, sir.
And you say that you want to do everything by the book. If you were proposing a completely new contract for him, you'd have provided him with that contract, wouldn't you?
Well, I verbally told him what the contract would be, and he said he would think about it. And then we went over a bunch of stuff in January, what his list of things that he was going to have to, you know, to do. And he said he'll think about it. In March, he came back. I mean, we're the same age. He's not a child. You know, I can explain the things to him verbally, and he can understand and take it back with him.
And if you were terminating
If he
him,
would have said, listen, I'll accept the offer, I would give him a formal offer with all his responsibilities.
and if you were terminating him, you agree that you would have given him a notice of termination, correct?
Well, terminate him for what? As an executive director? He was only in there in the capacity of the transition. So we talked about him staying on. I told him a price. I told him his responsibilities. He said no. So he was not a salaried employee after we took this on. It was not like we're going to pay you, X amount of days. You start this day. There was a number that was discussed. He declined that in March. We talked about it in January. I do believe we discussed it before that. And in March, he declined the offer. So he took 3 months to decide whether he wanted to accept the offer or not from January to March.
He didn't stop being a salaried employee at any point, did he?
I never considered him a salaried employee. He didn't work. He didn't come to an office. He didn't come to our office. He didn't come to meetings. He wasn't on Zoom calls. He didn't see clients. I mean, I don't know what our, maybe we have a different opinion of what defines an employee. An employee to me means someone who's actually doing work. He did the minimum amount he had to do to keep the license going while I took it over and in the transition period, which I believe is about 1 to 2 hours a week in emails with the auditors. So
well, you referred to the auditors.
I never thought of him as a guy who doesn't go to the office and doesn't go to meetings and doesn't strategize a business and doesn't go to conferences and doesn't do any of these things. That's not an employee. I mean, I don't know anybody in the world that will work without getting paid if they would consider themselves a salaried employee. For
You've
2 years.
You've referred to the auditors. Let's look at 1185 in the PDF. So this is a letter of representation that is sent to Baker Tilly, the auditors. If we just scroll up a tiny bit, please.
Was this sent by Amitesh? Or was this sent
Well,
by, who was this? No, it says Coinvesting, so probably not Amitesh.
let's have a look down.
April 30th, 2000.
Keep going to the signature page, please. You signed this letter. And if we look up at paragraph 34,
Can you scroll back down, please? To the signature?
yes.
Okay, we can go back up. When was this sent? Okay, April 30, 2023. Okay, go ahead.
Paragraph 34. Referring to end of service benefits as at the reporting date amounted to US 12368, completely owed to the SEO of the company.
Yeah, I never saw this, and I would need to read the whole document.
But you signed it, Mr. Vellucci.
Go back down to the signature. I would have to refresh my memory with this document. I can't answer it.
And we see the company.
I think that this is probably. Go ahead. Sorry.
No, you go ahead.
No, go ahead.
And we see other places in which the company recognizes Mr. Gahlowt as an employee. Can we just go back briefly to
I don't think this was. Okay.
899 PDF, just to refresh your memory. No, okay, don't worry about that. Let's go to 1103. So this is a director's
I'm sorry, can I ask you where you got this document? This last one? Is that from Baker Tilly?
The position is, Mr. Vellucci, that you've addressed this document in your witness statement, but you appear to be completely unable to say anything meaningful about it. Do you agree with that?
I need to see what document you're talking about. I'd like to go back to the last document. I'm trying to ask you, did you get this document?
Let's go back to the last document.
Yeah.
I think it was 1170.
And are you saying this document was produced from Baker Tilly? I mean, can you tell me? Okay, co-investing, dear sir, we confirm that the following reposition are made on the basis inquiries, management staff, and relative knowledge and experience sufficient to satisfy ourselves. This was April 30th, 2023. So I think what has happened is that somebody has just went and put something from the accounting, which was probably not taken off the books, over to this. Okay. You can go to the next document.
Well, can I first of all just say this to you? You've commented in detail in this document, in your witness statement. But, you know, I put it to you that this is not a document you you can give evidence about, because you clearly are completely unfamiliar with it, correct?
I'd have to. I might have acquainted myself with it when I gave my statement. I just.
And if
I
we
looked
go
at,
to
I looked at a lot of documents, so I just have to
PDF
reacquaint myself with it.
1103, this is a directors general meeting. You are the chairman
I'm
of this
wondering
meeting.
why it's saying Banyan Tree Asset Management Limited. It was changed to Co-Investing. By that time, I believe.
Again, Mr. Vellucci, this is a document you addressed in your witness statement, but you don't make the point there that you're making now, do you?
Say again, I'm sorry?
You don't, in your witness statement, say this document is wrong because it has the wrong company name, do you?
No, I do not.
And in fact, the name change did not occur until February of 2023, did it?
I'm not sure when the name change occurred.
And you are recorded here as being the chairman of the meeting, if we scroll down. Now, do you remember, because if not, we can go back there, but do you remember the DFSA said you have to hold a board meeting?
Yes.
And do you remember that the DFSA said you have to provide us with the minutes of the board meeting, yes?
Yes.
So do you agree that this is an important document?
Yes.
And if we go down, so chairman and quorum, this was a virtual meeting, correct?
Yes, I believe so.
Point number 3, change of control, recital of this. If we go down, so the corporate documents are hereby approved, so that it's all waved through, correct?
Yep.
Then we go down shareholders of registry, ultimate beneficial owner. We go down, please. Down. And then we have number 5, ratification as appointment as directors, you and Mr. Gahlowt, correct?
Yes.
And then SEO. The SEO of the company is Amitesh Gahlowt and has been approved by the DFSA. There are no other employees at the company at present. So it follows from that. It follows from that, does it not, that he is formally being recognized as an employee here, correct?
Well, I guess you could read it either way you want. I would say more likely yes.
And we go to 1114 PDF. If we go down, we see that these are minutes that are produced. If we go down a little bit further, these are minutes that are produced by Unitas, correct?
Yes, I believe so.
And you then say that it's disingenuous of Mr. Gahlowt. This is let's go to 322, which is PDF 337. Five lines down. That there is simply no credible basis for you to say that Mr. Gahlowt knew that his employment had been terminated, is there?
Well, he was an employee. I mean, you're asking me a question about a man that never ever showed up to a job.
So your
So, I
position
mean,
is can I just clarify this, because you've made the same point a few times. I just want to clarify.
yeah.
Your position is that because he was not turning up in the office, Mr. Gahlowt was not an employee. Is that your position?
No, it's a million things. It's not just showing up in the office.
Well,
It's
let's just deal with the office, because at this point, we've got to January 2023 in the minute we were looking at. At this point, the position about the office is as follows. The company has entered into a sublease with Neovision, correct?
yes.
But the office was being fitted out, correct?
No, the office, there was always an office being paid for. Always. During the whole duration, you have to have an office in DIFC. This was a new office. The old office was still being paid for. Obviously, you have to have an office in DIFC to have a regulated
You
fund.
do have to have an office, but the point is, it is not actually a functional office. It is not a
Yes,
working office.
yes, of course it is. It's a working functional office. It's a shared office space. There's a desk there. It is an office place. You can get coffee. There's bathrooms. It's an office.
That was the old office. Do you not agree?
Well, there was two offices. They had one at Emirates Tower, and then we had another one that was a shared office, and this was the new office. And at no time was there a lapse in the old office to the new office. So during this fit out period of this office, the old office was there. And I have several offices. I have an office in I have an office in JLT. He could have came to that office every day.
And the position is that you knew perfectly well that he was still an employee, didn't you?
No, I never considered Amitesh an employee. I considered him a transitional. The only reason that he stayed on as an SEO before we took over the company is so that the whole transaction would go through. If there wasn't a payday for him getting paid, why would he stay on that company for, I don't know, 2 years or 18 months? Of course, there was some sort of money that him and Sanjeev would have talked about. I assumed, and I believe it was made in conversation, there was also a finder's fee that he was getting for finding a buyer for the company, along with Unitas. He didn't do anything that would make an employee.
Mr. Vellucci, you're just making things up here. There is no.
I'm not making things up.
There is no finder's fee. There is no finder's fee being paid to him by Unitas, is there? What evidence do you have of that?
I said a finder's fee was paid to Unitas, and I believe he was getting a finder's fee too from Sanjeev. That's what I said, not from Unitas. So it was hinted on that many times by Amitesh. Like, oh, okay, well, what are you going to get into this? What are you getting in for this? Don't worry, I'll talk to Sanjeev. So I assumed, he never said I'm getting a finder's fee. I assumed that he meant finder's fee when he said that he was going to talk to Sanjeev and Sanjeev was going to take care of him. So
the position here, Mr. Vellucci, is that Mr. Gahlowt's interest is very simple. First, he would like the company to carry on because he has been at the helm. Second, he wants to be paid his wages, correct? It's not I
disagree. You're saying he was at the helm. They were about ready to lose their license. Their license would be taken away from DFSA. That is someone, not as someone that's at the helm. That is a ship that's off course, and there's nobody at the helm. I think just showing that their license was about to be taken on DFSA shows the fact that he was not doing anything. They were not doing anything. They weren't doing anything in the guidelines of what they were supposed to do. He was not at the helm of the ship. Absolutely not. He was not at the helm of the ship. He was not an employee. He never showed up to work. He never did anything that an employee would do, except for, I do give him credit, he kept up with the auditors and the things that he needed to do with DFSA. He did do that. He answered emails. He answered anything that kept the company going as almost like a shell corporation until the transition took place. And after transition took place, he also did those things for, I would say, 3 or 4 months. So he did do some things that kept it up, but he did not do anything that would constitute an employee of making $13,000 a month. Absolutely not.
The truth of the matter is that he was working, but you did not consider the work that he was doing to justify a salary of 13,000 US dollars. Isn't that the position in a nutshell?
Well, he wasn't working for me. He was working for Banyan Tree. So if you're talking about when I took over the company, absolutely no. I don't think he was doing the job to make $13,000 a month. Considering the past that they had in Mauritius, considering his past had no past of being an SEO or a director of a company or running a private equity fund, I didn't feel that he had the job qualifications to be making $13,000 a month as an SEO. But
And
before that,
complain-
it's not up to me. It's Sanjeev. He's the owner of the company. They're running the company. I can't tell them and dictate what they do and do not do with their company.
Mr. Vellucci, you know perfectly well that we're talking about the period after you taking over.
I don't know what you're talking. I don't know which period you're talking about. So if you tell me specifically what period you're talking about, then I can answer the question. But
It's
in
quite
my opinion,
simple. That
it was before or after.
Just if it helps you, Mr. Vellucci, there's an approach. So we've covered the meeting in November 22. Yeah, we've covered a company board meeting in January 22, January 23.
Okay.
We've looked at some accounts from end of April relating back. So we're talking about the period after you take over.
Absolutely not. He was not an employee. He did not act like an employee. He did not do the work of an employee. He did the bare minimum work that he needed to do to get us to the transitional phase, which is what he agreed to, and it's what the FSA wanted him as a director.
And the next point is you talked about private equity, but your background is in fact in software, correct?
My background is in investing software companies. I've been an investor for 20 years. So, yeah. That gives you a lot of experience in how to deal with clients.
You complain about him not attending events, but the position is that the company is not authorized at this stage to take on new business, is it?
You can go to conferences. You can do a lot of things to do something for a company. You can have strategies. If I'm paying someone $13,000 a month, I expect them to be at the office every day working. That's setting up frameworks for the company. It's comprising, if you're talking about finance, comprising cold list calls they're going to use, getting leads, getting high net worth individual leads from buying these leads, getting them organized. How are you going to market to them? You're going to do this. You're going to send them emails. This is a normal job that you do. You have to sit 8 hours a day in an office working. It's not something you do remotely. For $13,000 a month.
And there is no email or message from you at the time telling Mr. Gahlowt you should be in the office each day. You never said that to him, did you?
He wasn't an employee. So why would I tell someone who's not an employee that he has to be at the office?
You never say to him.
He was never at the office before we bought the company. He was never at the office after the company. He was never an employee in my eyes.
You never say to him, you have to attend the office each day, do you?
No, I do not.
And all of the complaints you're making are complaints you're making because you don't want to pay him money, correct?
Sir, I've been in business for 20 years. I have never not paid an employee their money, ever. And I've never had a labor dispute. If I owed him money, I would pay him money. There's nothing special about Amitesh. He's a nice guy. I didn't dislike Amitesh. There would be no reason for me not to pay him money if I owed him money.
Why on earth would he work on if he wasn't being paid?
Oh, that's my question too. I have no idea why he worked for Sanjeev for 18 months and didn't get paid. I couldn't ask you that. You'd have to ask him. I don't know I don't know a human being in the world that would work for 18 months without getting paid. Probably not even more than 2 months without getting paid, especially an executive.
And page 321, that's electronic 336. Paragraph 47. You talk about what he's been doing. And you say he was partly grateful to me for having ensured Mr. Singh paid him. I also understood he was continuing to work in the hope he could secure a better contract. In retrospect, I wonder if he was letting the situation drift in the hope that he could later gouge money out of the company by claiming that he was salaried $13,000 a month.
No, yeah, 100%. He tried to do that when this case came about. He never mentioned any money ever being owed to him from me, ever.
What this is about, Mr. Vellucci, is that once you've been faced with an employee persisting in a claim for their wages, you've decided to throw a lot of mud at them. That's what's happened here, isn't it?
Absolutely not. I've paid every employee that I've employed, which is hundreds and hundreds of employees, over 20 years. And I've never had a labor dispute on any of my companies against me, ever. And I made sure this man was paid before I paid the owner. That's the truth and the absolute honest truth. Not one time has this man asked me for money. Not one time. Not in an email. Not in a verbal besides taking in 50%. He's never asked me for money. In any WhatsApp message, in any email, in any verbal context, in anything. Someone who was, if I'm an employee and my boss owes me money, I'm sending an email or complaining to the HR daily. Where's my money? How come I haven't been paid? You owe me money. He's never asked me for anything. So I'm not slinging mud at him.
And the position is that you had a series of meetings at which he sought that you pay him. Do you agree with that or not?
I'm sorry, say that again.
There were meetings between you in which he asked you to pay him.
There was meetings between me and him that he asked me to pay him. I don't know what you mean by that. Could you be specific? Like pay him what?
Well, you just said very confidently a moment ago that he never asked you to pay him.
Yes.
But you actually know that he did, didn't you?
Well, if you're asking about 50% of his ongoing salary, that would be a case where he asked me to pay him.
And the position is that I think we can deal with this briefly. There is a meeting in March in which he says, you have to pay me my salary and my past dues. Do you agree with that or not?
Are you talking about in March after we're talking post, right? Post takeover.
Yes. March 2023.
Yes. When I got that email, I realized right away, what is he talking about? Okay. He's sending an email, so he's up to some shenanigans.
And let's go to 1116, which is bundle 1131. Go down, please. And what has happened at that meeting is that he has said to you, I cannot carry on like this, correct?
Carry on like what? Where, in reference
not
to a discussion
being paid.
to the subject of my resignation from the board of the role, I would like to term my resignation. I am okay to support what dues? These are my payable salary and benefits as per employment contract with Banyan Tree, asset management limit, now co-investing. Yeah, I was confused. I didn't know what he was talking about. He was paid everything he was owed when we took it over, and we never discussed him being paid after takeover. It was a transitional period. And then when we talk about keeping him on as a employee, I gave him a bunch of stuff that he would have to do as an employee in January, which was coming to the office every day is that's without saying, this is a private equity fund in DIFC. It's not a call center. So I gave him a list of things he would need to do. You have to contact clients. You have to bring in a certain amount of money per year from new customers. Normal stuff, things that an SEO would have to do for a private equity company.
And after this meeting, what he says to you is, I'd like to resign.
Well, go ahead.
I'd like, let's get it precisely. It's in this email here. I would like to tender my resignation. I'm okay to support till the time you find a replacement.
Well, he was always giving his support. That's the whole point. He was never a salaried employee. He was just doing this for us for the transition period because he knew that DFSA was one of the requirements. He wanted to, I'm sure, get all his money that was owed to him before from Sanjeev, which I got that for him. And he tendered his resignation because he did not agree, I'm assuming, on the $10,000 salary that we're talking about giving him, and probably the list of requirements of what he'd have to actually do as an SEO.
And the truth is, you did not consider this at the time to be a resignation email, correct?
Resigning as a director in SEO? Well, yeah. How else would you read it? I would like to tender my resignation. I mean, there's no other way. There's no other way to read that.
What he's saying
with
is
reference
not,
to
I
our
resign.
discussion today on the subject, with reference to our discussion today on the subject of my resignation from the board and the role of SEO, I would like to tender my resignation. There is absolutely no other way to read this.
Yes, it's very funny, Mr. Vellucci, isn't it?
I mean,
when documents are unhelpful to you, you've never read them and don't understand them. But then when you think, this document might be unhelpful for the other side, so you get very close in your reading
this
of it, don't you?
This is not unhelpful to the other side. It's in plain black and white. You're asking me questions usually for an email that pertains to something else. You're asking me what's in the email. Well, this is exactly what's in the email.
And both of you.
I mean, you're asking me what I think about this email. That's what I think.
Both. Well, it may be what you think today, but it's not what you thought at the time, was it?
How else would you read this email, sir?
Why did not refer to this email until April 2025? You cannot have considered this an important email.
Why is that?
Because you just never referred to it.
Well, we also didn't.
Months of correspondence.
We didn't talk through emails. We talked through WhatsApp, and we talked through phone calls. We never corresponded through email, and the whole time I knew Amitesh. So the only times I was CC'd, unless you're talking about like an auditor situation, but when me and Amitesh talked, we never talked through email. That's why there's hardly any emails talking. He just started seeing emails, I think, at the very end of this whole thing. So we had conversations via phone and we had conversations via WhatsApp. And after he left WhatsApp, I deleted his WhatsApp. I'm assuming he deleted my WhatsApp, and that's how we communicated. We didn't communicate that often through email. I mean, if ever, really. So I got an email from him. Go ahead. I'm sorry.
The simple position is that when you received this email, your reaction to it was to say, what dues, correct?
Well, I believe that was an email before this or after this. It's not.
Well, it's the email above it on the page here.
Yes. So if we go up.
And then he says, if we can go up on the page.
I mean, it's a chain email. So are you referring to email on a different date, or are you referring to this email? That's my question.
Good morning. These are my payable salary and benefits as per employment contract with Banyan Tree Asset Management, now Coinvesting. I'm confused. What exactly are you talking about? I gave you an offer in January, which you turned down.
Yes.
So what you're basically saying to him here is what becomes an argument you develop, which is that unless and until he reaches an agreement with you, you're not paying him anything. That was your position, correct?
No, we never had an agreement that I was going to pay him anything. He was staying there through the transitional phase after we took over. We talked in January about him staying on for $10,000 a month. In March, he said, no, I'm not taking that. I resign. I resign my SEO position. I resign my board of directors. I don't know how much more clear it could be in these emails. What am I going to answer? I mean, there was no answer. Okay, I find a new SEO. I find a new director, which I did.
And what actually happens is that you have a meeting. You've referred to your office in JLT. You then have a meeting with Mr. Gahlowt there to talk about this position, correct?
Are you referring in January?
No, we're talking. This email is sent on the 19th of March, and I'm putting it to you that after that you have a meeting with him at JLT, Do you agree with that or not?
I don't agree with that. I don't believe we ever met after this email,
And
if I can remember correctly.
what
I mean,
happened?
he's resigned. Why would we have a meeting?
And what happened was that you agreed that you would match his requirement for $13,000, correct?
No, okay, let me just think. April, May, June. No, I don't believe that me and Amitesh ever spoke again in person or on WhatsApp after these emails. This is 2023, March. Yeah. No, I don't believe we ever spoke.
And you then said to him, you can have this money going forward, but you have to write off your claim for past monies, correct?
Absolutely not. I never had a meeting with him and JLT discussing this. These are, I think, the last communications I ever had with Amitesh was these emails. I never had a meeting after this.
And how the meeting broke up was that you and he had not reached an agreement.
I think you're referring to a meeting before these emails, sir. You're referring to a previous email, which I believe is the email in January. There was no meeting in JLT after these emails.
And what then happens is that he agrees reluctantly to carry on, correct? Do you agree with that?
Absolutely not.
Well, then why didn't he just walk out the door?
We didn't have any meetings after these emails. I think he was probably at your office around this time.
And the position is that we have an email chain that we can then see at bundle. You say you don't have any communications with him. Well, okay, let's have a look at.
Well, if this is the meetings after Sunday, March 20, 2003.
Well, let's look to save time. Let's look at 1147.
There was no meeting in my office after this date in DIFC.
1147 PDF, which is bundle 1132. So we have 2 months later, after the audit has been done, and you knew the audit had been signed off on the 30th of April because you signed the letter of representation, correct?
You're asking me to remember something that 3 years ago. I have to see it.
Well, it was the letter that we looked at earlier.
Okay, got it. So I'm sorry, what is the question?
So the position is, I think you accept that Mr. Gahlowt carried on working through the audit, which is completed on the 30th of April. Can we at least agree on that? Do you at least agree on that?
Can you give me the date again?
30th of April, 2023.
March, April, May. I'm not sure. I couldn't tell you. I don't. I mean, he might have. I don't know.
1147 PDF. That is. Down. So the audit's been gone through, and he then says this email.
Is this? I'm sorry. Is this before the last emails you showed me, or after?
This is after.
Okay, got it. Okay, with reference to my discussion regarding my resignation and my overdue salaries and dues contribution, request you to clear my dues and let me know by when I can be relieved. Well, he was already relieved. He already resigned. He resigned in March.
We go up. And what you say is, you don't say, what are you talking about? What's all this about? You say, I'll be back on the 3rd of June.
Okay. So I was probably on vacation, I'm assuming.
Then we go up. This is on the 10th of May. He's offering you a Zoom call, correct?
In case discussion is required, we can do that via Zoom. Okay, yeah.
Up. Mr. Aslam, I think a Zoom call next week will be good. We need to draw a line under this one way or the other, please.
Okay.
And the 15th of May, trust this email finds you well. When are we having the Zoom call if required?
Okay.
And he
Am I
spells it
am
all
I
out.
s- am I CC'd on this email? I'm assuming I am.
Dear Enzo and
Well, yeah, but I'm looking for my email. It just says Dear Enzo and Isaac, but I'm looking for my,
the
email that
position
I was
is,
CC'd.
Mr. Vellucci, you're being very cautious about making any admissions, correct? Even
Oh,
when it's
I've
very
no,
obvious that something is.
I've realized at this. I'm sure I've realized at this point that he's trying to do some shenanigans. I'm positive probably by this point. I probably already started contacting uh, my attorney or something. I can't tell exactly what the dates. This was a long time ago, but I'm not seeing me attached on this email. I'm sure I'm assuming I am, but could you show me?
If we go up,
Yep. Okay.
if we go up, please.
I think at this point, I think at this point I realized that he's up to some shenanigans, and it was probably best just to uh, have lawyers involved.
And he's chasing for a Zoom call. And are you saying you've been on vacation all this time?
What? I have no idea. This is a long time ago.
And what
But I rarely take vacations, so
what I suggest to you, well, let's keep going up. Look, and then he chases you. I regret bothering you. I had this discussion on March the 18th. And he says it's been 2 months now, and it has been, correct?
since he's emailed me,
Yes.
yeah, it's been 2 months since he's emailed. I guess if you're reading the dates correctly, I didn't owe him any money. There's no money to be
And
paid. There was no dues to be paid. I realize at this point that he's trying some shenanigans.
keep going up. So we can see this carrying on. So your evidence, to be clear, is that you weren't replying to these emails because you felt that he was doing some quote unquote shenanigans. Is that right?
I think so. I don't know the exact time I figured that out, but I did figure out at some point since he never sent emails.
And then
before.
we can see, are you happy that you're copied into the email at 1128 that we're seeing up there on the screen? Your email address is there, isn't it?
Yes, it is. Okay.
Down, sorry, up. Up. And then on the 5th of June, Mr. Aslam said, can we set a date to iron this out? And then he says, one way or another, decision is required to be made so the firm can move on and commence activities. The longer we wait, the more irritated the DFSA will come. And so what Mr. Aslam is telling you in very simple terms is that this question about Mr. Gahlowt, his past dues, and whether he is carrying on as SEO and running things needs to be ironed out, correct?
It looks that way, yes.
And then we go up. And then we see another letter. And as we've now already understood why you're not replying, let's just go up. I was going to go through this email, but I'm going to save some time. And then finally, on the 3rd of July, we have this email from you between the tram lines. I've told you repeatedly you need to talk to your old company, Banyan Tree and owner Sanjeev. And this is the position you set out, correct?
Let me read it. Yes, I see it.
So the first point I'd make here is, you're coming out swinging. You didn't live up to your fiduciary responsibility to your investors, and there might be culpability on your part in this scam.
Yes. There was investigations in the Mauritius Bank, and they were bringing customers from the UAE, taking their money, sending it over to the bank, and they lost all their money. And he was complicit in that.
And
they didn't have a good track record, these guys. So he was not someone that I was going to pay $13,000 a month to.
And then there's a reference to, it's stated by you in front of 4 witnesses that you would remain as SEO during the interim of the sale. That goes back to the meeting in November at Unitest. That's the meeting you're referring to, isn't it?
You remain as CEO for the sake of selling the company, which Sanjeev paid you for. We were gracious enough to give you some money to answer some monthly emails. I'll be back Wednesday and we'll discuss further. Okay, you remain as SEO for the sake of selling the company, which Sanjeev paid you for. Yes, this was what I was also referring to, and I thought that he was getting a finder's fee.
And then you're suggesting that he was in India for 6 months. After you've taken control, have 6 months even elapsed?
No, he was in the India for at least 3 months for his mother's passing.
Yeah, but that was long before you'd taken over, correct?
I don't know when it was. I think it was before I took over, yes. It took another 5 months.
So what's happening, I just put it to you very simply, is that what you're doing here is you're making a series of very aggressive allegations, and the reason you're doing it is to try and warn him off bringing any kind of claim, correct?
No, not at all. I'm just stating the facts.
Yes, but why didn't you state those facts 2.5 months earlier when he was first emailing you about this?
Well, I probably did state those facts to him in a verbal conversation. We never talked.
But you just denied that there was such a verbal conversation. You said you didn't meet after his email of March.
I said in previous verbal conversations. I didn't say a month before or 2 months before. So we talked verbally. We didn't talk through email. I'm sure I sent this email knowing that he was doing up to some shenanigans.
And what I put to you is there's a much simpler explanation. Can we now go to the supplemental bundle, please? And can we please go to Your Honor? I have to say that would be a convenient moment, but I'm happy. I'm minded just to press on. I just mention it.
How much longer?
I've got about an hour and a quarter left.
With this witness?
Yes.
So does that mean that if we've got an hour and a quarter, we have to take a break? How long do you think you'll be with Mr. Aslam?
Well, one of the reasons why I was actually suggesting that this might be a convenient moment is so that I can have a brief conversation to see whether I can cut back further on Mr. Aslam. I mean, I am mindful of time, but I'm equally mindful that there are a number of matters that people may realistically want to be put, and I want to come back to the court with a clear answer on that.
So you're suggesting we take a
well, it's. I think
now.
It was scheduled. Was it scheduled for 12 o'clock, or have I got it wrong? I think it was scheduled for 12 o'clock.
Yes.
I could be wrong.
Yes, it
It's
was
just
12:15.
What I'd be grateful for is if we could come back. I'm not suggesting 1 o'clock. I would be suggesting 12, 12:45, 12:50.
That's fine. Why don't we come back at 12:50, which is 3:50 p.m. UAE time, and you can let us know how long you expect to be with Mr. Aslam. We can take a view whether we can try and finish all the evidence today as we had intended.
That's right. I'm grateful, Your Honour.
Thank you. Okay, we will adjourn. Mr. Vellucci, you are still under oath, so please do not.
talk to
speak
anybody?
to anyone about your evidence.
And I mean,
Certainly.
just to be clear, Your Honour, I'll be spending. I should mention there's in terms of the bundle. I'm now in the supplemental bundle, but obviously there are bits of the trial bundle I need to go back to, particularly the bits from. It's about page 1100, but we're making good progress. Bearing in mind that there is correspondence in it at the end.
Yes. Okay. Right. Thank you. So I will
Thank you.
see everybody in just less than 1 hour.
I'm grateful.
Thank you.
I'm grateful.
Okay.
Let's
So
continue.
everybody can see and hear me?
We can see you and we can hear you. Yes. Thank
Okay.
you.
So in the supplemental bundle, can we please go to page 184? And in this case, the PDF and hard copy page numbers match. Down a little bit, please. So what we see here on the 15th of June is Mr. Aslam sending you an email on the 15th saying, further to our conversation yesterday, that would have been the 14th, please find below summary of decisions made. 1. Edwin is to apply to act as the licensed director and SEO. 2. Amitesh shall be removed as the SEO. 3. No other director. So the position is that while you are not replying substantively to Mr. Gahlowt, what you're actually doing is working with Mr. Aslam to replace Mr. Gahlowt as SEO and to appoint someone else, correct?
I'm sorry, this is after his resignation email?
This is on the 15th of June.
And his resignation email was in May, am I correct? May of 2023? Or March, I'm sorry, March, right?
It's your evidence, Mr.
I know, but
Bellucci.
I'm asking. Okay, so in March he resigns for a Tory conversation. Yesterday, please find below summary of decisions made. Evidence applied to act as the licensed director of CEO Coinvesting. Amitesh shall be removed as CEO for now. No other director will be appointed as there's no activity. Yes, this is. I think I was on this email. Yeah.
And we see, just if we scroll up, that Mr. Gahlowt, if we go up further, we can see who's, no, we that's too far. It's just to see who's in this email chain. So we see who is in copy and Mr. Gahlowt is not, correct?
Yes, he's not. He resigned, so he wouldn't be on the in the email
And
chain.
we go up to 182. And here we are, Mr. Aslam again. You, Karen from your office, Sagir Mohammed. This is what you're told. This is what Edwin is required to undertake to prepare his essay. This was Edwin from Neovision, correct?
Yes.
And they've generated an application for him. And we then see do you agree that at the same time that the bank was told to change the account signatory from Amitesh?
I started that process for the bank to change his signature, I think, long before this. Long before this.
Okay, well, that's...
I think. Citibank. Or at least add me. It might not have been taken out completely. I can't remember.
Okay. The problem with this is simply whether I go to the main bundle for it. I think it's not important enough. So we then have supplementary bundle still, page 186. This is an email from the same lawyer we saw negotiating the SPA for you, correct?
Yep.
And he's been told as of the 18th of July that Amitesh is no longer part of the business and that the marriage ended pretty badly. Let us know about documents, correct?
Yes.
But then if we go back to the main bundle, please. We can go back to the main bundle. We see 1200, which is 1215 in the main bundle. Let's put this into some context, sorry. What we see is, I'm just trying to save time. Yes, can I go to 1205 PDF, please? We'll come back to this in a moment. And we go, and this is what Mr. Gahlowt is being told on the 26th of July. I submitted the attached to the DFSA on the 24th of July. No comments surrounding the report. Saida did indicate that she will review the IND 1 and the IND 3 when they're submitted. Now, just to be clear, an IND 1 is something for someone joining in an authorized function, and IND 3 is somewhat for someone when they're leaving, correct?
I don't know. You'd have to ask Isaac that.
If we then go to 1215, which is where we were a moment ago, we can see that what the DFSA are told is the firm and the present SEO have decided to part ways. The withdrawal forms for Aut-Ind will be submitted by the firm within 7 days of the date on which the SEO ceases to be employed by the firm, in accordance with Gen 11.7.1, in due course once that date has been confirmed. So there's no suggestion here of denying that Mr. Gahlowt is an employee, is there?
Who wrote this? Or by compliance department? You'd have to ask. It looks like this was Unitas that wrote this.
And what
so,
they're being
I mean, what Unitas comes up with is something Unitas comes up with it. But as far as we were concerned, he was never an employee.
And what then happens is it says in due course once that date has been confirmed. So put it to you that Mr. Gahlowt reading this would be under the impression that there is still a hope of negotiating an amicable exit. Do you agree with that?
Of course not. He resigned in March. He was never an employee. He knew he had to stay on the company until we found a new SEO. That's what that's what he signed up for.
And then if we
that's the transition process.
And then if we go back to the supplemental bundle, please.
Also, when he says he resigned, he said, "Hey, I'll stay on to help the transition." go through.
You agree that he never gave a definite resignation date in that email?
I don't agree. He said, I resign. That's a resignation. You don't say
Yes.
I'm going to resign in 2026. If I tell my employer, which we're not an employer, but if I tell an employer as a worker that I resign, you resign basically immediately. If you don't put a date, that I resign, in whatever September 1st, then it's assumed that they're resigning immediately.
Page 197. We see that on the very next day, what we have is the DFSA writing to, sorry, it's not the very next day. The email is the 29th of August, but what we see in the substance of it is on the 25th of July, we received your firm's application to give this person authorized status. We approve him effective the 29th of August, and he's going to be a licensed director and senior executive officer. But that email confirming that change is not sent to you until the 29th of August. We then go, so you agree that Mr. Abramo was duly applied to be, an IND1 was submitted for him on the 25th of July.
He replaced Amitesh, yes.
And if we go to 187, the reason I asked you is there seems to be some confusion about whether this happens on the 25th or the 7th, but it says here, I've submitted the application to remove Amitesh as the SEO and submitted Eddie's application to replace him. And then as a compliance order, officer, I need to stay independent, etc. So again, to state the obvious, Mr. Gahlowt is not copied into this, correct?
Well, he's not a part of the company in any respect. I think after March, so there would be no reason for him to be copied into an email. He resigned.
I put it to you, Mr. Vellucci, that you know perfectly well that what you're doing here is you are replacing Amitesh without telling him, so that you can get him out of the company, yeah, and present him with a fait accompli, correct?
No, he resigned in March. He was not part of any company emails, I believe, after March or after he started seeing these emails. So why would he be? I mean, I'm sure Isaac probably had some communication with him because there had to be a process that somebody talked to him about, I guess some sort of sign off with DFSA or something to move them over. But yeah, I mean, I can understand why he wasn't attached to these because he wasn't part of the company. So, he says I resign in March and he says, but I can basically keep my name on there until you find a new SEO and director. I mean, that's how I read the email.
Are you denying that you were deliberately keeping all of this secret from Mr. Gahlowt?
There was no secret. He was never staying as the SEO or the director. He was just an interim transition after I bought the company. So, well, I have to explain my answer. I made him an offer in January. He turned it down. He resigned as an SEO and director in March. I mean, there was nothing to keep from or hide from him. There's nothing that we did that was deceptive or tried to be deceptive. If he resigned in March, why would he be, why would we have him on internal emails with the company at that point?
Can we go, please, to
So the answer
main
is
bundle?
no. We were not trying to be deceptive to Amitesh.
Can we go, please, to main bundle 1191 of the PDF? So this is an email from Mr. Aslam to Amar Jassim at Citibank with you in copy.
Mm-hmm.
I trust this email finds you well. I'm the compliance officer, evidence of my role. I write this email on behalf of the 100% ultimate beneficial owner, namely Enzo, who is CC'd. Please note the following. 1. Enzo has reached out to you via email to remove Amitesh as a signatory over the account. Can you please advise what steps have been taken? 2, we require the account to be maintained. We would instruct Enzo for the outward remittance as soon as practical. Then, please note the above email is a direct instruction from Enzo and no communication to Amitesh regarding point 1 be discussed with him.
Yes, absolutely. He was not part of the company anymore. He shouldn't have access to the bank account. We started removing his access from the bank account. I think it's a total guess, but somewhere between January and March. So this was known. Amitesh was at the bank at Citibank with me when we discussed it was a Citibank. Citibank took months and months and months to get their due diligence done on me and on the company and everything, even though they had all the due diligence on the company. So yeah, why would we? We didn't want him on the bank account at this point because he was the only one that could withdraw money. He could send out wire transfers. There was lots of money in the bank account at that point.
What you're doing is taking a whole set of steps to exit Amitesh with him knowing as little as possible.
This is not exiting Amitesh. This is removing him from the bank account, which had lots of money in it. He was an acting director and acting SEO. He was not the SEO running the company or running any day-to-day operations or anything remotely. Why would you let a guy who's not running the company have access to millions of dollars? This is standard. I wouldn't have him, especially with not having. It took a long time for me to be added to the bank account. So at any time he could have wired out any amount of money with absolutely no supervision, without having to have two signature authentication apps. So we immediately started removing him off the bank account and putting my name in the bank account. And Amitesh was at every single one of those meetings at Citibank, which I believe started in, I want to say, December, November, the previous year, or January. So it was a long process to get me put on the bank account and Amitesh taken off the bank account. We weren't trying to conceal it. He was at all the bank meetings. Amitesh was.
And if we go down,
they wouldn't even have a meeting with me unless Amitesh was there. I'm not even authorized on the bank.
We go down to 1177. Which PDF 1192. Down to the bottom. So in fact, we're talking about a dormant status account.
Yeah, dormant because they didn't do anything with it.
Are you seriously telling the court that there are millions of dollars sitting in this account?
When I had put my capital requirement in there, yes. I don't know what month that was, but there's a capital requirement of over $550,000. So there had been $550,000 in a capital, and then you have to have expenses for at least 90 days to 6 months. So yes, there had to be at least $1 million in there. And I couldn't do anything at the bank without Amitesh going to the bank with me. He was the only signatory on the bank account. So in every one of these meetings I went to the Citibank, Amitesh was there.
If we can go back, please, to the supplemental bundle. At page 100 and let me do this manually. 189 of the PDF. This is the IND3 application. Let's go down one page. And we can see at the top, this is submitted on the 7th of August. And we go down, current date, 7th of August, then we go down a page. And again, we have a series of important rules about the necessity for accuracy. And we looked earlier at the DFSA letter about the firm needing to maintain timely and accurate documentation with it, correct?
I'm sorry, what is the question?
We looked earlier today at the DFSA requirement letter, which said the firm has got to do the following things, and we went through them carefully, and they included having timely and cooperative communication with the regulator and being accurate in submissions. Do you agree that?
Yes.
And so what we now see is please select the task you would like to complete, withdraw an authorized individual. Then we go, who is being withdrawn? Amitesh. And then we go to the next page. Who's completing this? Mr. Aslam. And we know that he did because he emailed you. Then we go down a page. And it's worth noting here on number 2, which is just at the top of our page here. This section must, no, sorry, we were just a moment ago. Yes, here we go. This section must be completed to withdraw the authorized individual principal representative of Amitesh Gahlowt. In some cases, the DFSA may require additional information. If it's necessary, they may be in touch. So we then go down a page. And it now says, when is the date that he ceased performing the licensed functions? That's listed as the 31st of July, which is an arbitrary choice, correct?
I don't know. I didn't fill this out.
And then 2.2, please indicate change of responsibilities, end of contract, resignation, which is not ticked. So all of your comments about him having resigned and left the organization in March, they are not what the DFSA was told, are they?
Well, I'm not the one that filled this form out, so you'd have to talk to, I guess Unitas is the one that filled this out. Maybe they filled it out incorrectly. I'm not sure.
And then we have the argument here, withdrawal of offer of employment. And it then says, please provide a detailed explanation. Reason we may need to increase the size of that.
Now I can see it.
Reason for withdrawal of SEO position are various, including the UBO being of the opinion, the UBO, that's you, do you agree?
Yes.
Being of the opinion that the SEO had not shown acumen to lead the business in addition to the salary expectations of both parties not matching after the UBA became the 100% owner of the company, correct?
Yes.
And the truth of the matter here is that despite these emails we've seen about you complaining about breach of fiduciary duty and so on, the reality here is that you had simply decided two things. First, you didn't consider that Mr. Gahlowt was as dynamic as you wanted him to be. Would you agree with that?
I would disagree. Their bank was closed down in Mauritius. Their license was about ready to be closed down in DFSA. They were not running a company in a regulated financial way that they were supposed to. That's why they lost a whole bank, and that's why they were losing their license. They were not of, in my opinion, they were not of good character to be. This is another reason why, I kind of wanted him off the bank kind of as soon as possible. So Unitas filled this out, I guess. I'm assuming why they put withdrawal of offer of employment, because they're going back to January when we offered him employment. He said no, in March. Maybe the person who filled this out, I don't know, maybe it was their office manager. Maybe she doesn't know that she didn't see a resignation letter from him. I don't know. I can't tell you about this. I didn't fill it out.
What I say to you is that this document reflects what became your argument, which was that
My argument. Go ahead. I'm sorry.
Your argument is that he's never been employed after the change of control. That's your argument, correct?
Yes.
And what I'd say to you is that that argument is an argument that you come up with once it becomes clear to you that Mr. Gahlowt is seeking payment of his salary.
Well, I can go back to my earlier statement and I can rehash the whole thing if you want. He wasn't working for us. He never was working for us. He stayed in the capacity of a transition role. That's it. I think that is very clear in all the paperwork and very clear in any communications. Did he? There's no email to the company asking for the 2 months off that he took in India. He didn't ask my approval to go on several vacations. He didn't ask my approval for sick days. He didn't ask approval for anything because he wasn't working for us. He didn't ask approval for anything. I mean, I don't have any employee that can just take off months and go out of the country, or take 6 days without telling HR, or any of these kinds of things. There's absolutely no, this is not. You can see this is not an employer situation. For me, it's very, very clear. So there's no stuff that we're trying to hide, or there's stuff that we're trying to be deceptive about. So
why was it that you only produced these documents last week after a pre-trial review hearing at which the judge expressed the view that they should be produced?
Which documents?
The ones we're looking at.
I don't know. Well, my lawyers I'm assuming, had the documents for a long time. I don't know why. This is the first time I'm really seeing this document.
And then if we go down to PDF 200, we see that on the 30th of August, the DFSA approved this withdrawal. And we've seen a match-up between that and when Mr. Abramo is approved for.
Mm-hmm.
So the position that you were aiming for, very simply, was one where Mr. Gahlowt was just going to be informed that he'd been removed from the as the SEO by the DFSA. Do you agree with that?
I don't agree with that. I think he was well informed that he was not going to be the SEO and the director. And if there was communications between Unitas and him, I don't think, and I'm not positive about this, I don't even think there's no way that you couldn't have informed him some way or somehow.
And
so he was completely informed that, a matter of fact, I believe Amitesh even met Edwin previous to all this. So he was well informed that he was not going to be. I mean, the guy declined the offer gave to him in January. So if you've declined an offer that's given to you in January, he waits 2 or 3 months, then says no in March. I mean, and then sends a resignation email. I mean, do you think this guy doesn't think he's being replaced? He didn't accept the offer that was offered to him, and then he resigned in March. I mean, for me, there's no other way to interpret this. I know you have your own way of interpreting it, but for me, it's pretty clear and simple. He was made an offer, he refused it, he resigned, and he offered to stay on there until we found a new SEO, which was gracious of him, and we found a new one, and we switched off and we moved on, and then all of a sudden he was saying that he was owed all this back money, and here we are today.
Now, can I take you now to 194, please? Because you were asking a moment ago about who completed this form. Let's have a look here. 194. Name of it designated individual authorized to make declaration. Director of head office or controlling entity. And then I understand that it's an offence to provide to the DFSA any information which is false, misleading or deceptive, or to conceal information, whether concealment, etc. So you are actually the person who, certainly you're the person whose name is on this document, but do you have no recollection of completing it?
I don't remember seeing this document. No.
And
was this a document in the portal, or was this a written document?
Looking at it, it looks like a portal document, but yeah.
I've never even logged into the portal. I don't even have a login to the portal.
And you see, Mr. Vellucci, I do need to put this to you quite clearly. What we've seen from you today is a very clear combination of two things. You're very clear about documents when you want to be. You claim that you've remembered them. You can explain them to the court. But when a document is difficult for your case, we have the kind of answers that we've just had. I don't know anything about this. Who put it in?
We have hundreds of documents, sir, and I'm the owner. I'm the UBO. I don't look at every single document that comes through the company. That's why we have SEOs, and that's why we have operating officers. So there's hundreds of documents, maybe thousands of documents. So if this was uploaded in the portal, I did not upload in the portal. I've never uploaded anything in the portal. So I'm assuming this must have been done by Unitas.
And could I simply just ask you this? If you'd received an email like the one at 1142, because we were at 1142 before we went off into the supplementary bundle. So 1142 is a PDF reference for everyone. If you'd received an email like this email here that we see in the middle of the page, I've told you repeatedly, would you consider that you had any future in the company owned by the person who'd sent that email?
I'm sorry, say again?
If you had received an email like the one in the middle of the page here, I've told you repeatedly, if you received an email like that from the ultimate beneficial owner of the company, would you consider that you had any future realistically in that company?
I've told you before. No, of course not. I'm simply I'm telling him right here. He was not an employee. He's still harping about some money that was owed from Sanjeev. I made sure everything was paid from the company before I paid Sanjeev. So he's still talking about some other money that I'm not aware of. I don't know if this is a success fee or something for selling the company. So definitely Amitesh knew that he was not part of the company. Even the day after the sale, he knew he wasn't part of the company, except for in the transitional period.
And the truth of the matter is, as we now see that email in its context, you've only come down on him like a ton of bricks at this stage, because by this stage you know that you have an alternative SEO lined up, correct?
This is in June or July. I don't think so. I think that Eddie was many months later, I believe, if we look at when Eddie got approved.
And it is also the case, can we at least agree this, you accept that you have not in 2023 paid Mr. Gahlowt any salary. You agree with that?
I wouldn't know, to be honest with you, because he was still handling the books after that.
Okay.
But to my knowledge, no. But
So,
you know,
so again, you've raised this question in your statement. You've said, well, I think, or maybe I'm doing you a disservice. Maybe it was orally. You've said no one would work on for this period of time without being paid, correct?
yes, I think that's
So,
inhuman, including Amitesh.
so we go to 1286. Of the PDF. And he resigns.
Well, you mean the second resignation or the first?
Well, let's be more specific. I need to be legally precise before I'm picked up on this by one of the lawyers here. What he does is he terminates his employment for cause pursuant to the DIFC employment law, and he does so because the employer, the employing company, has behaved in a manner which is contrary to basic employment practices.
Mm-hmm. Yep, I see it.
So
We
I have
fought
to
for
put
him
to,
to get paid every penny was owed to him, and this is what we got in return.
and what is actually the case here is you have talked in your statement about how you feel that you've been cheated by Amitesh, how something's amiss.
I never said I was cheated by Amitesh. I said he was never an employee, and he had went through the whole transition phase before we bought it and after we bought it, which is what he agreed to in the very beginning. So he did those duties, and he worked 2 or 3 hours a week, answering emails for the auditors, answering emails. He did the bare minimum he had to get the ball across the line. But he was not an employee. He was not running a company. He was not interviewing employees. He was not looking for office space. Matter of fact, he's never even been to the office, I believe, at Co-Investing in Gate Village 5. So I didn't say he cheated us. I said, you know, he's cheating us now by coming back and trying to get a bunch of money that we've already fought for him to get paid. And then he didn't want to agree to the employment contract. He didn't want an employment contract. He didn't want to accept the money. And then we found a new SEO, we found a new director, and now he's coming back for, I mean, massive amounts of money, $300,000 or $400,000.
The position here is
I
this.
feel like I'm being cheated now, yes, but I don't think he was cheating us, until this stuff started.
The position, Mr. Vellucci, is this. You needed Mr. Gahlowt as SEO at the time of the change of control, correct?
Correct.
You needed him
Well,
for ongoing.
Let me rephrase that. We needed an SEO. Sanjeev kept Amitesh on there. I can't tell that company, I don't own the company, to remove him as SEO and put another SEO on there. So I'm sure that it was smooth. And then DFSA pointed out that they wanted him to stay for the transition period and become a director for the transition period, which he did. So
and you
I really didn't have a choice to replace him right away.
Yeah, and so what you do is you get, it's very simple. You get from Mr. Gahlowt what you need from him, but you don't pay him for it, correct?
No, absolutely wrong. I paid that. I'm the one that fought for that man to get his money. Me, only me. Not Unitas, not Sanjeev, not even Amitesh. Me. I made sure he was paid every single penny that was owed to him. And that when we closed that deal before Sanjeev got paid. That's it. That's the facts of the case. That's exactly what I did. And here I am today fighting hundreds of thousands of dollars in legal bills and hundreds of thousands of dollars of quote unquote back pay.
And you
I never once set out to do anything deceptive to Amitesh. Amitesh is a nice guy, to be honest. I had no problems with him personally.
And what you have done is, when it has become clear that he is pursuing his contractual and statutory entitlements to pay, you have exited him in a secretive manner. Point number one. And point number two, what you've then done is you've turned around and said you've never been employed at all. It is an incredible position, isn't it? We have someone here who is recorded.
Absolutely not. That is not what happened.
He is recorded on multiple official documents as an employee. His pay is being accrued in the company accounts. He is doing work for the company. And yet you are claiming at the end of all of this that he has never been an employee after the change of control.
Yes, that's what I'm saying.
There is simply no credibility to that position. If you wanted to dismiss him as an employee, what you needed to do was to send him a formal written dismissal letter.
He was not an
He
was not an employee. He was in a transition period, and he resigned in March. He resigned. The email is pretty clear that I resign as SEO, and I resign as director. So,
and later, you need him later to get it's not just the change of control, because then you need to complete the transaction, and part of that is him becoming an executive licensed director, correct?
That is correct.
And again, what you do, even when he tells you about this past dues dispute, is you press on because you want to complete the transaction, correct?
No, absolutely not. I got that man his money. Everything that was owed to him, I got him his money. Me.
And then
nobody
later,
else. I paid the money.
Later,
I fought for him to get the money, and I paid the money. And that money went to him.
And then later, what you have done is to come up with a series of arguments for why he doesn't deserve his money. It's as simple as that, isn't it?
Absolutely wrong.
Your Honor. And you have spoken with passion today about your view of this case, but I put it to you very simply that what has happened here is that your anger at potentially having to pay money has led to you lying to the court in your evidence.
I have not lied about any evidence I've given to the court.
In particular, you have lied by claiming that you relied upon emails from Mr. Gahlowt about his entitlements before proceeding with the transaction. Do you agree or disagree?
I have every single thing I've said today is truthful. If I mixed up a date or I mixed up a document, that's human error. But everything I've said in this hearing today is the truth. And not my truth, the truth.
And you have also not told the court the truth about what happened in the meeting with Unitas, have you?
Which meeting? There was a lot of meetings with Unitas.
The meeting that we spent a great deal of time discussing, and which you are very well aware of, which was attended by 4 people discussing the completion of the transaction, Mr. Gahlowt's salary, etc. You cannot seriously pretend at the end of this evidence now that you do not know which meeting we are talking about, can you?
There was several meetings with the 4 of us in there. So if you're referring to the last meeting, the wrap-up stuff, I absolutely told 100% the truth. I fought for this guy to get his money. He was paid his money. Him and Sanjeev decided on what that amount would be between themselves. I paid Amitesh that money, and I paid the owner his money, and I took control of the company. That's the truth.
Your Honor, I don't think purpose is served by me going through the full evidence and putting this repeatedly, so I'm minded, in the interest of time, to stop there.
Thank you. Thank you very much indeed. Mr. Doherty, do you have any questions in re-examination?
I think just two things fairly briefly. First of all, if I could ask that we pull up the supplementary bundle. So my instructing solicitor is listening, but I'm looking for supplementary bundle at page 194. You will recall, Ms. Vellucci, relatively recently in your evidence, you were shown this document and you were being asked questions about whether or not this was a document that you completed. And I think you were shown this declaration, which referred to you as UBO and director and making a declaration. Could we scroll up in this document to page 192? There's a page which has the title Contact Details of Individual Completing Application. There's a name underneath and some contact details. I think you had given evidence that you don't recall who completed it, but you didn't think that it was you. Does this assist in your recollection of who most likely would have completed this document?
Yeah, Unitas. So, yeah, Isaac worked for Unitas.
Thank you. And if we could go, please, to the main bundle, to paragraph 16, I believe it's paragraph 16 of your witness statement. Oh, sorry, paragraph 19, which is at page 315. And in paragraph 19, you referred to some discussions that took place about splitting the costs 50-50 with Mr. Singh. And I think there were some questions put to you suggesting that you had agreed to pay 50% of outstanding dues. As I understand what you had said in your response to that, was that what you were talking about was payment of 50% going forward. In the context of that, you asked to go to and were taken to page 342. And you referred to the email from October 27th at the top of this page, which is an email that you weren't copied into. But it was the email which made reference or purported to make reference to you verbally agreeing to share the cost of remuneration. And you were asked similar questions about whether your recollection was that it was in relation to outstanding dues or whether it was in relation to dues going forward. Could I just ask that you read the email which you weren't shown at the bottom of the page from the 16th of December?
Dear Sanjeev, I had a discussion with Mr. Enzo Vellucci regarding my salary. and remuneration. He said he will not take anything on him from April 21st as it was discussed with him. However, he is ready to share 50% of my salary cost since October 24th, provided we show him that 50% of the salary has been paid by BTML first. Request you to please look into this. Okay, I've read it.
Does that email assist your recollection on whether what you were discussing was payment of all past dues or whether it was payment of matters going forward?
I was never aware of all this money that was owed to him until the end of closing. When me and Amitesh had these discussions verbally, I think he said that Sanjeev was a month behind or something like that, or maybe 2 months behind. And I'm assuming this is in December, so I don't know, we've got maybe 6 months or 7 months have went by now, 8 months. I think the deal was supposed to be 90 days. So I'm sure Sanjeev at this point was like, "Hey, this deal hasn't gone through. It's been 90 days. I came out of pocket a lot of money for the expenses of this company for 18 months." And so I think probably what happened is Sanjeev, didn't pay him. And then he came to me and asked if I would pay 50% going forward. And I said, as long as I was seeing the 50% coming back. But if I had mentioned anything in the past arrears, I would have had no idea. And I was never told that he was not being paid. I think from this evidence shown today, he wasn't even paid from before I was even involved in buying the company, if I'm correct. I think he was even 2 months behind pay there. I think if I read the dates right earlier in the evidence. So I was never aware that he wasn't paid any money from the company or Sanjeev up to the point where we had a verbal discussion about this.
Okay, thank you. Nothing further from me, Your Honour.
Thank you. I have a couple of questions. Could someone please assist in screen sharing from the trial bundle page, PDF number, page number 1142? Right, Mr. Vellucci, I want to refer you to your message of the 3rd of July to Mr. Gahlowt. And the third line from the bottom, you remained as SEO for the sake of selling the company which Sanjeev paid you for. We were gracious enough to give you some money to answer some monthly emails. I just want to know, what were you referring to when you said you were giving him money to answer some monthly emails?
Amitesh asked for some cash. I don't know, maybe it was around the time his mother passed or something like that. So I gave him some cash. I think I gave him around 20,000 dirham one time, and I think I gave him 10,000 dirham. So I had given them some cash because I guess I don't know, he didn't really explain why, but I just did it.
Right, was that after you had taken over control of the company or before? Because I recall it being discussed earlier that his mum passed away before you took over control. I may be wrong, but I thought that's what someone said earlier.
That was before.
So you gave him some cash before?
Yeah.
But the answering of the monthly emails, are you referring there to what he was doing after the change of control, or you're referring to what happened before?
I'm sorry, let me read it again. Investing responsibility.
Because you're talking about him remaining as SEO.
You have never for one day been to our office, worked on our behalf, and talked to our. As a matter of fact, you earned here for 6 months on the sake of selling the company, which paid for. We were gracious enough to give you some money to answer some monthly emails. I think I'm obviously referring to probably the cash payments I gave him.
Right, because is it the case, I think you confirmed this earlier, that as far as you're aware, after you took over the company, while he was SEO, which ended in August 2023, he wasn't paid by the company at all. Is that correct?
He was not paid by the company, no.
And you had offered him $10,000 a month, but he refused that.
Yes, in January.
And while he was SEO, he had access to the bank account, which you said had significant sums in.
Yes.
So was your expectation that since he didn't accept the offer that you had made to him, that he wasn't going to be paid at all? You said, I think he did 1 to 2 hours of work a week in the SEO role. Is that right?
Yes, he did.
Right. Sorry. Yes. Your expectation.
My expectation was that it was kind of like a package deal, that I got him all his money that was due to him when the sale was done, and he basically was staying along for the transition, and it was kind of all part of a package. And then if we were to keep him on, it was going to be a different package, and we talked about that, I think verbally a couple times before January. Then we had a serious meeting about it in January. I made him the offer. I told him all the things that he would have to do to get that $10,000 a month salary, and then he turned it down. And I believe March was the first time I heard back about it, and he turned it down.
And I understand he was on an employment. Go on.
I felt that it was just something he was doing for the transition of the sale, because it had to be done. GFSA, it was a stipulation of GSA that he be a director, so he had to be a director for the deal to go through, basically. And that's one of the reasons why I made sure that he was paid everything he was owed from Mr. Sanjeev.
Right. And I understand he was on an employment visa with the defendant.
He was.
Right.
We tried to get rid of his employment visa. I can't remember which month we started. I think we started right after March, but we couldn't remove him from the employment visa because it's kind of a catch-22. Unless he signs off, you can't remove him. And then he wouldn't sign off, because then he started this case about for the back dues and the back fees. So he remained on the visa for a long time.
Okay, thank you very much indeed. Thank you. You are now released as a witness. Thank you for your assistance. You're free to go. And I think we should take a short break now before we hear from Mr. Aslam.
I'm very sorry to interject. There's just one point arising out of literally the last words of evidence. I would just I don't think this should be contentious, but in terms of the sign-off that Mr. Vellucci just referred to, what he's talking about is does he accept what he's talking about is the claimant signing a document saying that there's no pending dispute between him and the company? That's what he's talking about in the catch-22 situation. I just think I should have that confirmed.
Is that a question for me? I'm sorry.
Yeah. Well, if the judge.
I mean, I understood him to be talking about the document that has to be signed for a visa to be cancelled.
Yes, yeah.
That's what I understood, but you need him to clarify that.
Yes, because in the bundle we do actually have the particular visa cancellation letter. And
does anything turn on this?
No, I don't. What turns on this is that we say that the company should have cancelled the visa and didn't need him to sign off. But that's a point of law.
And I'm not even sure if it's still a live issue, but
we tried to cancel his visa so many times, and we're told that we couldn't because he didn't sign off. He wouldn't sign off on the cancellation.
Right. Is that satisfactory?
Yeah, I mean, we again disagree about the date. We say it's from October, not March, but I think I think one has had enough. So there we go.
Wonderful. Thank you again, Mr. Vellucci. We are going to take a break now, and we're going to come back at 5 p.m. UAE time, which is 2 p.m. UK time. And then we'll hear from Mr. Aslam. Thank you.
Thanks.
Right. Welcome, Mr. Aslam.
Thank you.
I'm going to hand over to the registry who will administer the oath or affirmation.
Sure.
Good afternoon. Please can I confirm whether you would prefer to swear on oath or by affirming?
By oath on the Quran.
And can I please confirm that you have the Holy Book with you?
I do.
Thank you. Can you please confirm your name and occupation for the court's record?
Mohammed Isaac Aslam. I am a compliance officer.
Please repeat after me. I swear by the Almighty God
I swear by the Almighty God
that I will say nothing but the truth.
that I will say nothing but the truth.
Thank you, Your Honor.
Thank you.
Right. Mr. Aslam, I will hand you over to Mr. Doherty, who will take you through your witness statements.
Thank you.
Can we bring up page 296 of the bundle on the screen, please? It's page 311 of the PDF. I'm not sure if it's possible to potentially try resharing that. I don't know that it's worked on that occasion. Oh, I see. I've just got a notification from my instructing solicitor that he appears to have been thrown out of the meeting.
Oh.
So I haven't got the camera working in this instance.
Is there any chance the claimant solicitors might be able to help us with screen sharing? Well, of course, let's do what we can to get him readmitted. Just give us a moment.
Yes. Yes. Mr. Doherty just gives the references that they'll put up.
Yes, so it's the page 311 of the PDF for the main bundle, and the page number is 296.
My screen's just gone blank, Your Honor. Not entirely sure what's happened. No, seems my screen's just gone off. Andy or someone, can you come into the boardroom?
The IT is getting tired, I think.
Yeah. My screen's off, Andy.
Do you have a hard copy of bundles there, Mr. Aslam? Oh, you're on mute. Do you know how to put yourself off mute? I don't know if you have access. No.
Suspect that without being able to see the screen, that might be the issue.
Right. So you're waiting for assistance. You can nod. Ah, you're unmuted, Mr. Aslam.
Oh,
Do you-
okay.
Yes.
I do not.
Okay.
I'm asking Andrew if there's a hard copy. Andrew, the judge has asked if there's a hard copy of the bundle. Yeah, we're getting a hard copy.
Only if there's
Your Honor.
one handy, but I think I
Yeah.
think it's going to be much easier if we can screen share, and it's going to be more efficient. I hope the IT are also helping to see if
IT are here. Yes, IT are here.
Okay, so they're trying
Yeah.
to make sure you can see a screen and
Yes.
not a blank
Yes.
screen.
Yes.
Okay.
Bear with us. I can.
Yes.
I'm on. I can now see the screen and everything.
Oh, wonderful.
Yeah. Hello,
Wonderful.
everyone.
Great.
Yeah, I'm online. Yeah. Thank you, IT. Thank you, Andrew.
So you should hopefully now be able to see in front of you a document which says first witness statement of Mohammed Isaac Aslam. Do you see it now?
Correct. Yes, I see it.
Excellent. And if we could scroll forward, please, within this document to page 310 of the bundle. That's 325, the internal numbering. We can see at the bottom of the page, there's a statement of truth and there's a signature. Could you confirm, is that your signature?
Correct. Yes, my signature.
And are the contents of this statement dated the 2nd of May true to the best of your knowledge and belief?
Correct. Yeah.
Thank you. If we could go, please, to page 328, which is 343 of the PDF. We can see the document titled Second Witness Statement, Mohammed Isaac Aslam. And similarly, if we could go, please, to page 330. You can see at the bottom of the page again, a statement of truth. Could you confirm, is that your signature?
Correct. Yes.
And are the contents of this statement true to the best of your knowledge and belief?
Correct. Yes.
Thank you. If you'll remain there, there will be some questions for you from Dr. Pickford Smith.
Sure.
I'm grateful. If you, what will happen is documents will appear on the screen, and if you can't see or read them, please do tell us.
Sure.
If we could go to 297 of the main bundle, please. Sorry, that should be, it's PDF 312 or 312. Yes. So you summarize your role at paragraphs 6 and 7.
Correct.
And then in paragraph 8, you talk about you were the face, effectively you were the face of Unitas, correct?
Correct for banyan tree at the time. Yes.
And the level of work varies from month to month, correct?
Correct. Yeah.
That is not particularly surprising given the position the business is in, is it?
No, it's typical for firms sometimes to go below 40 to 16 hours. And if there's any risk assessments or any high risk onboardings, we typically go above.
And then there are some sort of busy moments of the year, for example, the finalizing of accounts and so on.
Yes, so finalizing the accounts, any regulatory reporting obligations, etc. So it does vary month on month.
And if we go down, please. You talk about the regulatory position. And then at paragraph 13, you say you were not focused on HR matters, correct?
Correct, yes.
Can I just take you to the supplementary bundle, please? Page 1. This is an HR manual of the business, and if we scroll down.
Yeah.
You comment on this manual, correct?
Correct. Looks IA1. Okay.
And if we go down to page 5, we'll see, and this I think is what persuaded me, at least reading it, that this was you, which I understand to be the case. So this is something that's done at the firm level, not compliance level. If you require this, it can be done, but the compliance officer will only run anti-money laundering checks. So effectively, you give a variety of comments on the manual, some from a compliance standpoint, and then others if we go down at page 6. Effectively, you can say you can help with an HR procedure, but please provide a first draft of it. And that request at the time, am I correct in saying that HR matters at the company are being handled by Zinnia Khan? Is that right?
Amongst other roles, I believe that was my main interface for HR. Yes.
And you have, and it's unsurprising because you've been in Dubai for some years. You have a sort of general awareness, if I may, of employment law. So if we look at page, say, 14. We go down. So you're saying, well, this is not really appropriate for Dubai. So you have what I would describe as a sort of passing acquaintance with DIFC employment law, but obviously you're not a specialist in it. Is that the correct position?
Passing, I'm not a specialist. I don't practice law anymore, but I was looking at it from a compliance perspective, and this, I'm looking at it now for the first time in years, and this appeared to be a bit odd to me at the time.
And you add the simple point, for example, in sick leave, you say, well, the reference here should be to the DIFC employment law. If you could see that sort of in your little insert in the page, correct?
Correct. Yeah.
Yeah. Now, Sue, if we could go back to the main bundle. We see that soon after you start, Mr. Gahlowt is appointed as SEO, and we can see that at 453. Sorry, 468. If we scroll down a bit, you can see that Mr. Gahlowt has become an authorized senior executive officer and senior manager, correct?
That's correct. Yeah.
Now, you explain it in your witness statement, and this is at paragraph 12, which we were at a moment ago. Hang on, let me get the correct one. Just go to this. Sorry, I have one here which does not have the bundle reference page numbers. Sorry, just please bear with me a moment. I'm just without one which has bundle page. Wait a moment. Sorry, I'm also having a minor. It's not a serious IT issue. I'm having a sort of brief moment here. Hopefully this will end. So this is at, I'm just going to the PDF now. This is at page 298 of the PDF. And sorry, 313 of the PDF. And you talk about some gen rules here. Can I just go through these?
Of course, of course.
The position is that you cannot be both a director and a senior manager because they're separate functions. Is that correct?
That's part of the gen rule books. You can either be a director or a senior manager. You can't be both at the same time.
And that's covered in the last sentence of paragraph 12. And if we go to gen itself, apologies for keeping moving around.
No. It's absolutely fine. Sorry, doctor.
No, that's fine. That's absolutely fine. So if we go to gen itself, which is in the authorities bundle at page 1117. What we see there, it goes through to 1118, and the reason I'm taking you through this slowly is because I'm pointing to an absence. It doesn't say anywhere here that a director cannot be an employee. That's not a rule, is it?
I don't see that.
No. And in practice, the position is that an executive director will normally be there and on an employment visa. Is that correct?
Not to my experience. It varies from firm to firm.
Okay,
some directors are not remunerated, some are. Some may also be employees, some are not. It depends on a case-by-case basis. It's not universal.
I think that was actually what I was trying to. Yes. But the distinction in practice, do you agree, is between a key distinction is between an executive and a non-executive director? I mean, that's generally understood, correct?
How do you mean?
Well, fundamentally, a non-exec is normally a semi-independent third party who sits on the board, whereas an executive director is someone who is involved in the running of the business, correct? As a matter of generality. Yeah.
Correct.
So one of that's enough of the gen for now. So one of the points that you pick up at paragraph 16 of your statement.
Yep.
Is that when the company hits financial difficulties, you were concerned that Mr. Gahlowt terminating himself or the company terminating him would put the business into a position of regulatory breach.
Potentially, if they didn't have a replacement in mind.
Yes.
Yeah.
And did you give any thought to the following fact? His initial employment contract, first of all, it was an old contract, but secondly, it provided on its face for a 2-year fixed term. So if the contract wasn't dealt with and not renewed, the same position would apply, i.e. that either the firm had to find a replacement or there was a potential for regulatory breach.
At the time, I was not aware of any employee's contractual terms. It's not something that I looked at.
Okay, well that saves us a few minutes, then that's fine.
Yeah.
So when going back to the position, if we go to page 469 of the bundle. If we go down, please. No, that's 469 is 476. Here we go. So you are emailing the DFSA with an update to explain what's happened, i.e. non-essential employees have been terminated. And it says not undertaking any activities. There's just one point of detail I want to deal with you here. The position is the firm is not allowed to and is not taking on new clients, correct?
Correct. During one of our calls with the regulator at the time, Tim, who's unfortunately passed away now, was very clear that the firm should not undertake any financial services activities due to the circumstances the firm was in at the time.
And one of the positions that the firm was dealing with was that there were a number of clients it did already have who sat with it from a regulatory position and dealing with that sort of administrative runoff of that and informing them of the position and liaising with the conservator in Mauritius. So that was one of the things that was going on at this time, correct?
Correct.
And just standing back from this, was it your understanding, if it's outside your area, you should feel free to say so, but was it your understanding that effectively the choices facing the firm were either one, wind down, or two, find a buyer?
That's correct. That was my understanding at the time. They were either going to wind down or find a buyer.
And would you agree that in terms of finding a buyer, that the value of the firm lay in two things I'd suggest to you. First, its license, and second, that it was a functioning business with the requisite authorized individuals, including you and Unitas, Mr. Gahlowt, the finance officer, also, of course, from Unitas. So someone wouldn't just be buying a bare license piece of paper or virtual piece of paper. They would be buying a regulated business that had the sort of functional bare bones, as you would expect a regulated business to have.
The absolute skeleton, yes. No clients, no custodians, nothing. Just the core functions.
It's the core functions, and there's no sort of silver lining in terms of some, pot of gold or silver in Mauritius or heavy client connections. It's just that the license and the pared back core functions, correct?
Correct. There was two schools of thought at the time. One, if the Mauritius bank was being bought out, perhaps the buyer of the Mauritius bank would also save Banyan Tree DIFC at the time, or shut down, or have its own independent buyer.
And from the DFSA perspective, it was the case that they were keeping a close watch on the firm because of the position it was in, correct?
Oh, absolutely. We would have calls weekly or every 2 weeks with Tim and Seda at the time.
And would you agree that alongside you, that the person who led at those meetings was Mr. Gahlowt in his capacity as the SEO?
led, I would say, more by me, but yes, Mr. Gahlowt was there for all meetings, etc.
And over time, the DFSA become very familiar with the two of you. I think that's a fair comment, isn't it?
Yes, I was with the DFSA for probably 5 years prior to that. Not working with the DFSA, but known to the DFSA. Amitesh was known to the DFSA relatively new at the time. He became the SEO and then COVID hit. So, but he became familiar with Tim and Saida, definitely.
And I mean, I'm not meaning to put this in an overly simplistic way, but I'm conscious that it's quite late in the day for some. The key role that you and Mr. Gahlowt had as a matter of sort of practicality is that you've got to make sure that the company stays compliant and on the right side of the DFSA, because you were under this close watch, and if the license was lost, the practical value of the business, I wouldn't say it disappeared completely, but it would largely disappear. Would you agree with that?
It would almost entirely disappear. So, correct.
And would you agree that that was really the key role that you and Mr. Gahlowt were playing at this time?
The key role as in?
Making sure the firm didn't lose its license and continued to be okayed by the DFSA in a broader sense.
Correct.
And with the sale, I'm turning now to the sale. Now, the position is that Mr. Vellucci was seeking a DFSA license, correct?
Correct. And
you inform him that it would be quicker to buy the defendant than to apply for a new license.
It wasn't myself who informed him, it was Sagir Mohammed, but Unitas did, yes.
And the transaction is proposed to Mr. Vellucci, and so if we go to bundle 504, which will be PDF 519, you send off the due diligence pack, and if we scroll down, we can. I'm not going to go all the way through the due diligence pack, but let's just go to page 616, which will be electronic 631. So these are the outstanding balances and the sale price, and then if we go down a page, please, or 2 pages actually. And it's listed here that there is an ongoing expense for Mr. Gahlowt and Mr. Gahlowt's dues contributions, correct?
Correct.
And you say this is bundle 300, so that would be 315. Because although you do say this, I don't want to get you wrong here. Paragraph 21, at the time, paragraph 21, line 3 at the right, at the time we assumed that Mr. Gahlowt would be retained post-takeover. Now, that's what you say in your statement. Now, in the negotiations with Mr. Vellucci lawyer, and there's just an example of this at 646, which will be 661, if we just go up a little bit. Oh, sorry, this has got out. Just keep going down. Keep going down. It's this email here. That's it. So a question that you're asked by Mr. Vellucci lawyer is, and I apologise, it's right at where the pages mix. But if you see at the bottom, we would like to know how many employees there, well, it must be there, are currently under the company's visa? If none, have they been terminated and their dues paid? And you explain at 657, which will be bundle 673. Is up slightly. And it's the bit you see that says visas in the middle. All employees have been terminated and all dues have been settled, correct?
Yes.
Due to the COVID pandemic, 6 people remain on visas. Cancellation of all visas can be determined the SPA. So this, just to put it simply, you know, you're very upfront with them. This is the position, and everyone knows where it is, correct?
Yes.
And the SPA is then concluded. Had you read the SPA?
Not in great detail, but I have. I did certain points in time. Yeah.
And were you aware of its provisions about where liability lay after the execution of the agreement?
Liability in terms of what exactly? What liability are you referring to?
That's a very fair question. Let me just go straight away here to the relevant clause. Sorry, I am trying to be brisk, but it is important that if you have a question such as that one, you raise it. So let's look at this. Can we go to PDF 682, please? So we see there the definition of effective date. Do you see about halfway down the page? And it's referred to as the date on which this share and license acquisition agreement is executed, and between the purchaser and the seller. We then have 600 PDF 690. We go down. G, we have this clause: the purchaser shall not be liable for any costs pertaining to payments. You can read it for yourself. You don't need to read it. You don't need to read it out.
Okay. May I see annexure A, just so that?
Yeah. Yes. If we go down, that's the question that everyone has, and you'll discover shortly that there's a reason I haven't taken you there.
Okay.
So, just looking at that clause, the position is that if we just go back to 6.6G, the position there is clear in black and white. At the end of the clause, all costs, whether specified or not, post the effective date will be to the account of the purchaser. So it's the purchaser who's liable to pay under the SPA, correct? Now, my question is not. Sorry, I should be more specific. Yeah. I'm not after a legal opinion. There are plenty.
I was just going to say.
But the question is a different one. At the time that these disputes about the SPA start cropping up and who's paying for what, were you aware at the time of this provision?
No. I didn't. I looked at the compliance terms, not any legal terms.
Okay. And one thing there,
to the best of my knowledge, yeah. Sorry.
One thing that you do deal with is the form that goes to the DFSA with regards to a change of controller. Can we go to 714, please, of the PDF? So this is the change in control function. And if we could just, you'll be very familiar with these forms. So if I think we'll just keep going down if we may. Can we get down to page 710, which will be PDF 725? And we see their impact of new controller. And it says right at the end, the new controller will retain the SEO, finance officer and compliance officer in order to ensure a smooth transition of the processes. Yeah. So you were therefore aware that the intention was to retain Mr. Gahlowt, correct?
At the time, yes.
And the question that the DFSA come back with at 721 PDF 736 is they come back precisely with, is there going to be a change in business model, activities or senior management of the firm? And you politely revert to them, we'll see this in the page above, to say our understanding from our meetings and conversations with the UBA is that there will be no change of business plan or activities for the foreseeable future. The UBA will retain authorised individuals such as the SEO, compliance and finance, and then you politely refer back to the document we've just looked at, correct?
Correct.
And there's also 663, please, which may be 663. No, it should be 678. And the position there on visas is that all of the visas except for Mr. Gahlowt's visa will be cancelled prior to the transfer of shares. So that's the position.
Yeah.
So what is happening in the meantime is this application is sitting with the DFSA. This is by now we've got to September 21. And effectively, you and Mr. Gahlowt and others at Unitas are really trying to hold the fort pending authorization of the change in control, correct?
Correct.
And what instead happens is that, and so one of the things you produce, or I assume it's you, so we go to 787, which will be 1002. Can we just check that is 787? I may have just got my maths wrong. I have got my maths wrong, sorry. It's 802. So this is an updated regulatory business plan. You inputted into this, correct?
I did indeed.
And we see if we go down, it's quite a long document. If we go down to 790, and again, at the very bottom of the page, it's exactly the same points. The new controller will retain the SEO, finance officer and compliance officer. And then if we go down to 806, we see that Mr. Gahlowt is listed as on the board. And then there are various standard corporate governance things about how the board will operate, correct? That's so function and broad frequency. And put it to you that all of this is quite basic in a sense. It's seeking to make a case to the DFSA that this is a business which is going to be run in accordance with good corporate governance and regulatory standards moving forward, correct?
Correct. As Amitesh will be the new director and SEO, and there was an indication of appointing a non-executive director as well. That obviously hasn't happened at the moment, but yes, of course, good corporate governance was at the forefront of my application.
And then 855, what we see is the DFSA coming in with a preliminary decision notice, which I assume a preliminary decision notice proposing to withdraw a license is something one hopes one doesn't see every day, correct?
Yes, that's correct.
And I just want, it's not a criticism of your statement, but you talk about a capital breach. But if we go down in this, if we go down to paragraph 8 in particular, please. We see really the DFSA, in a sense, listing a series of concerns that it has. Particularly, we see it 8B1, 8B2, 8C, 8D, and then, in a sense, there are more specific things: failing to update the DFSA on its current premises address.
That's correct.
So, would you agree that after this letter comes in, you and Mr. Gahlowt work hard on representations to the DFSA about why you should be allowed to retain the license, correct?
A lot of work was undertaken on my side, for sure, yes.
And, well, he inputted into it as well, would you agree with it?
Yes, there was assistance, but I had to lead this. So it was mostly from my side, yeah. Well,
I mean, I can't remember whether this has already been in evidence, but so apologies if it has been. But you had previously done a great deal of compliance work, so this was your area, correct?
Yeah, of course, yeah.
Yeah, and suggested to you that one of the key factors in persuading the DFSA to allow the firm to retain its license is to provide reassurance that you and Mr. Gahlowt will be continuing in your roles, correct?
Sorry, can you say that again? Sorry?
One of the key reassurances given to the DFSA was that you and Mr. Gahlowt would be continuing in your roles.
I would say for continuity purposes, yes, but we put together a significant remediation plan to help address all of these concerns and why some of these were insignificant. But yes, that formed part of the wider representations we made.
Yes, and in terms of the wider representations, I'm just going to give one example. One of the things you did is you say, well, we're going to have a functioning board, it's going to meet, etc.
Yeah. Correct.
So the DFSA come back and we see this as 872, which must be 887. And here we go, and we go down and we see a series of conditions on page 2. And that's where you are. In other words, there is a remediation package that they have said, this is what you have to do. Do you agree?
Correct.
So to put this shortly, Unitas is being paid a finder's fee for the transaction. Is that correct?
A finder's fee, yes.
And this is a transaction where you have led on the regulatory materials.
Correct.
And the straightforward position is that both you and Mr. Gahlowt are working hard to try and get this change of control through. Would you agree with that?
Correct.
And you became aware, did you not, and I need to be. It's a very long process, this change of control. But shall we say that by the time of the DFSA approval of the 5th of July, you were aware that Mr. Gahlowt was complaining to you about not being paid his salary, correct?
There were conversations. We were friendly, and he would say, "Yeah, he hasn't been paid."
And one of the key things that follows is negotiations between Mr. Single, the vendor of the business. Did you dealt with Mr. Single, correct? Quite a lot, yes?
I wouldn't say quite a lot, but I have dealt with him.
And you dealt also with Mr. Vellucci, correct?
Yes.
And were you aware that there was a standoff between Mr. Vellucci and Mr. Singhal about who was paying, who was going to give the company the money to pay Mr. Gahlowt's salary?
There did become a standoff. Yes, became aware.
And you said that you were aware. It's important to say that until a particular meeting I'm going to come to in a minute, and until that meeting, the position is you are not yourself party to, let's take this in turn, you're not party to any discussions, direct sort of face-to-face meetings or discussions between Mr. Vellucci Enzo and Mr. Singhal about who's going to pay those costs, correct?
Correct. I wasn't involved. I don't believe they actually had spoken, but if they did, I certainly wasn't involved in those conversations.
And likewise, you're not party to conversations between Mr. Gahlowt and Mr. Singhal about these matters, are you?
Unless they were on email, I was not involved.
So when you give your evidence at paragraphs 35 and following of your statement, have you got a separate copy of your statement, or did you just have
I
it
don't. I don't. Sorry.
Okay. Can we try 320? This is a guess. Can we go up, please? Up to paragraph, 36. So if we go up further, effectively the position is 35, 36. You're copied into these emails, correct?
I believe so, without seeing them in front of me, but I believe
Well,
so.
your evidence.
These in my evidence, yes, of course, yes.
Yeah, I'm not trying to. So when you say my understanding was at paragraph 36, that is an understanding you have taken from the email traffic, correct?
From the email traffic, yeah.
Then if we go down to paragraph 37, you say, I note that he's included a sum, and then you say, I did not notice this figure at the time, but I find that odd. So just dealing with your contemporary knowledge, the position is these are, to put it simply, they're emails that come into your inbox. Unitas are clearly, this is one of their clients. It's something that takes roughly 10 to 15, 14, 16 hours of your week. So it's something you would, I would say, have a peripheral awareness of, but you were not actually involved in, correct?
Yeah, so if I could just correct, 14 to 16 hours a month, not a week.
Yes.
That's number one. And stuff like salary payments, etc., wasn't my concern. My concern was whether an SEO at the time was in place.
So it's not a criticism, but it's a statement. The reality is, isn't it, that these paragraphs of your statement are more about. I mean, you said it's not a criticism. It's paragraph 38, for example, in the middle. Whilst I was not paying a great deal of attention to the exact figures and dates, the position is that yes, you're seeing these emails, but really your evidence about them is the evidence simply of you. Well, not simply, but it's the evidence primarily of you going back and reading them all now. Correct?
I had surface level understanding, but at the time, and my at the time was payments were to be made in November 2022. That was meant to be the final settlement, and then there's going to be an agreement going forward. What the figures were, who was paying, I didn't. From my perspective, all I as a compliance officer, all I needed to understand is there an SEO in place, because we need to have that in place because it's a mandatory function.
And you say at one stage that you are surprised by the figures. This is at paragraph 42 of your statement. You say I had no idea he was claiming that sum of money. Can I take you, please, within the bundle to I mean, let me put it another way. Was that surprise a surprise informed or not informed by reading the relevant financial statements? Did you read the financial statements and how they accounted for dues, for example, and other figures?
No, that was the finance officer. From the finance officer side, all I wanted to be, as a compliance officer, all I wanted to be made aware was, is there enough capital? Is the EBCM sufficient? And from my perspective, as a compliance checkpoint, that's all I was worried about from the finance side. Otherwise, I'll be doing the finance job, risk job, HR, everything. It'll never end. So.
And at paragraph 42, 3 lines from the bottom, you say, yep. I had clearly understood and believed that Mr. Vellucci had understood. Now, that is your understanding from what Mr. Vellucci has said to you by email and otherwise about his surprise at these figures, correct?
Yeah. It says final net balancing owing to employee.
And one question I had, because you've picked up on that wording, but were you aware of do you remember we looked at those references to termination in the context of 2020, and we were talking about that, and you were explaining your concerns about him being terminated? Can we just go in the trial bundle, please, to 484, which, will be 499. So here we see a series of termination letters. This is a sample. If we could just scroll down. And we have a sample termination letter. Now, is this the type of letter you'd be familiar with seeing?
I've only seen this type of letter for banyan tree, at the time, banyan tree.
And normally, do you see letters containing different terms? I mean, if you can't remember, you can say so.
I don't really remember.
You don't really remember.
All the only terminations that I need to be fully abreast of are the license functions, because that needs to be reported to the regulator. And as you can imagine, they're few and far between, license functions, compared to normal employees.
And then we see at 486 a schedule of full and final settlement, correct? So we see various things, and then we see this actually physically signed by the employee to confirm that they agreed with these figures, correct?
Correct.
Now, it's the position, is it not, that the documents that Mr. Gahlowt is producing are materially similar to this template, correct? To this table we're looking at 486.
Sorry, so the documents that Mr. Gahlowt is producing is similar to this?
Yes. Would you agree with that?
But in what context? In the context of the terminating of these employees?
Yes. You comment at, for example, in paragraph 42 of your statement about particular points, and the point I'm making to you, or the question, is not a point I'm making. It's a question I'm asking. It's an open question.
Okay.
The question I'm raising with you is that there's actually a degree of similarity between that and this type of document, correct? If you don't want to comment, that's fine.
I'm not sure what that document is that you're referring to. What that document is. This is one, but what that document is.
Okay.
I'm so sorry, Doctor. I'm not trying to.
No. It's fine. It's absolutely fine. Can I now turn to paragraph? I think we may be on safer ground with paragraph 43 of your statement.
Mm-hmm.
This should be at PDF 304. You say, if Mr. Gahlowt had indicated, I have no doubt this would have completely derailed the negotiations, correct?
Correct.
Now, it's in that context that I want to take you back to paragraph 34 of your statement, where you talk about a meeting that occurred at your office between you, Mr. Mohammed, Mr. Gahlowt. And this was a meeting, was it not, that was also a meeting attempting to discuss how to complete the SPA transaction.
Pending items on the SPA, correct.
And there are a number of issues there, and one of those issues is Mr. Gahlowt duly applying to be a licensed director, correct?
That was one of the, so on the business plan we said he was going to be a licensed director, so that was one of the points that we had to apply for, correct.
And it's in that context, isn't it, that there is this conversation. Now you say, I remember that they discussed that this is lines 3 and 4. Then you say in line 5, my recollection it was that it agreed that Mr. Gahlowt's salary would be reduced going forward to about 30,000 dirhams. Now,
correct.
Just taking this in turn, you've gone straight, as it were, to the potential resolution, but the actual position was this became quite a heated meeting. Would you agree with that?
It did. I wouldn't say heated. I would say passionate, but yeah.
And would you agree that at that meeting, Mr. Bellucci Enzo made very clear that he simply didn't think that what Mr. Gahlowt was doing was worth $13,000 a month, and he made that point forcefully? Would you agree with that?
I don't recall the exact wording. I just simply recall an offer was made of $10,000, 30,000 dirhams going forward. And
you may not recall this, but after Mr. Vellucci Enzo explained why he didn't think Mr. Gahlowt was worth the money, Mr. Gahlowt then said, well, if that's the position you're going to take, I'm going to withdraw from this licensed director application. I'm not going to make it, correct?
Honestly, Doctor, I don't recall.
And your then boss, Mr. Mohammed, as I think, yeah, he is called your boss. Sorry, I didn't want to be over. Yeah. Your boss.
I don't like the term boss, but yes.
Yeah. Well, I just went there anyway.
Yeah, of course. Yeah, I wrote it, so.
Yeah, that's fine. He said, look, everyone, let's sort this out. We're very nearly there on this transaction. Let's try and, move forward on it. Would you agree that's in very general terms what happened?
That sounds like an apt description of him, but I'm not entirely sure what was said, but that sounds like an apt description of what he may say.
And so I just need to put one point of disagreement with you and then move on very simply. The point of disagreement is that we say that there isn't actually a deal at 30,000 AED, but that's an offer that's made and it's not rejected and it's sort of out there for discussion. I mean, that's the one point of distinction that we would draw. Do you want to comment on that?
The comment that I have is, the comment that I have is it would have been accepted, otherwise Mr. Gahlowt would have refused and we couldn't have made the application at the time.
Well, now there we may be disagreeing, but only minorly. What I put to you about this is that certainly he left the meeting with the impression that a deal between him and Mr. Vellucci was certainly imminent, and that everyone could move forward, but they didn't actually sort of sign on the dotted or clasp hands or anything like that.
There was no signed agreement. There was a degree of informality. Everyone was working towards a goal. So there was consensus that we could move forward with the application.
And I do just need to put this to you, that there was no sense coming out of this meeting that what was happening was that Mr. Gahlowt was stopping being an employee, leaving the company or anything like that.
Leaving the company, no.
And in terms of what then happened, there are a string of later emails involving you. I think I just want, in the interests of time, to come to the point. You know that as a matter of fact, the company did not, through payroll, start processing monies to Mr. Gahlowt and paying him either $10,000 or any other figure, correct?
Sorry, can you repeat that?
I
know as a fact. Yeah.
You know as a fact that the company did not start processing payments to Mr. Gahlowt in, let's say, January, February 23. It wasn't paying him either $10,000 a month, $15,000 a month, or any monthly salary. You know that to be the case, correct?
I now do. As I said, looking at figures is not something that I concern myself with.
And with regards to the, did you later become aware of a dispute between Mr. Gahlowt and Mr. Vellucci about two things? One, whether he was being paid. Two, how much he was being paid. You may or may not have become aware of that.
I wasn't aware until an email was sent.
And the email that you refer to is the email at 235, which is PDF 250.
No. This is domain stuff.
sorry. So, I think I must be. I'm afraid that my problem here is that I have written on a copy of your statement which is does not contain the correct references. It contains references to your thing. Could those instruct me just send me an extra PDF? Yeah. Yes, trial bundle 1116, please, which will be 1131 PDF. We go down. And this is the email, is the correct place in the email. If we just go back up, please. So you refer to this, and you say you understood from this that he'd resigned, albeit he was willing to support in a more limited way. Now, I suggest to you the following. First, you knew that as an SEO, it wasn't that simple. If he was withdrawing from the business needed to find a replacement. Point number one, correct?
Yes, if he was, yes, it's a mandatory function, so we would require an SEO.
Point number two, you actually spoke to Mr. Gahlowt after this email was sent, and he said to you that he was going to go and meet Enzo to try and sort matters out, correct?
Correct. My conversation with him was, okay, if you're going to resign, then we need to find an SEO, and but there's an audit happening. I believe this was in March, and he was best placed to serve for the audit. That was my conversation with him.
And one difference of recollection there is that I put it to you, he did say, do not worry, I will be around to help with this. He told you that, correct?
Yes, after the conversation about the audit, correct.
But what he didn't say to you was, oh, I have a 30-day notice period. He actually made no reference in that conversation to his notice period. He simply said that he would be around for the audit and staying on.
Well, then recollections are different.
Okay. Well, I put it to you.
Yeah.
Then the position is that in fact Mr. Gahlowt sticks around well beyond the end of the audit. He's definitely there. For example, you would agree in May and June he's doing things. And can I put a very specific date marker here? There are a series of emails in the bundle which I would like to go to, please. So we have 184. Sorry, this is now. Let me just. I'm going to try and. Yeah, it's not that. Go back to. Why don't you go back to the main bundle? That's fine. I can do that. So we have let's go to 1132. I think this is the quickest way forward. If we scroll up. So we have here this email chain. It continues, and we just keep going up, please. No, this is the wrong one. Can we go down to 1132? Go down. Keep going down. Keep going down. So the payables document we just saw splash past is this document containing a series of dues, and you were aware that these were the level of payments that Mr. Gahlowt was seeking, correct?
When he put it forward, but again, I didn't pay too much attention.
Okay, can we keep going down? Can we try one? Can we just keep going down? I think we're virtually there. Here we go. Right. So we see here, let's stop it there. What you say is that this dispute has gone on. You say, I think a Zoom call early next week will be good. We need to draw a line under this one way or the other, please. And by this, you mean the standoff between Mr. Vellucci and Mr. Gahlowt about these unpaid dues and the question of whether he's carrying on as SEO or not, correct?
Correct. I'm compliance officer. My role is independent. I need to be impartial. So I just needed a resolution. The firm was not doing any business. Nothing was happening as a result of the situation we found ourselves in. The firm found itself in. So I need, but this is not the only email. I wrote several emails to basically say we need to find a resolution.
Yes, if we scroll up, I was trying to find. Sorry, apologies here. I was trying to find the place where they all are, and this is the place where they all are. Yeah. So we have another email here of the 15th of May from Mr. Gahlowt chasing a Zoom call. We have it again above. And Mr. Vellucci's response is, I'm away on non-working vacation, correct?
Yeah, that's there.
And how this matter ultimately resolves, we see in the supplemental bundle at 184. This is an email you send. Oh, if we just go down a little bit. Saying these are the decisions that were made yesterday, which must be at the 14th.
What date was this email?
If we just go up, sorry, the email, it's the end of the day for everyone. 15th of June.
Yeah.
Please find below summary of decisions made. So Edwin, that was a gentleman, Edwin Lee, correct?
Yes, Edwin Lee.
And he's to apply as the licensed director and SEO. Amitesh shall be removed as the SEO. No other director shall be appointed as there's no activity. But this is, you say here, kindly confirm your instructions via email so we can generate the online application for Edwin and circulate the resolution for both you and Amitesh to execute. But there is, in fact, no such resolution is circulated to Mr. Gahlowt, is it?
Correct. I don't think Edwin accepted the role as director and SEO.
And instead what happens is Mr. Abramo becomes the SEO in due course, correct?
That is correct.
And what we then have is page 186 of this bundle. You receive an email from Mr. Vellucci's lawyer saying this has been no longer part of the business, the marriage ended badly, and discussion of documents. And then we see 197 we see that on the it needs to go down a little. Yes, on the it says there on the 25th of July, you've received the firm has made an application to give this person authorized individual status, and you, as a matter of practicality, would have uploaded that to the portal. Is that correct?
I believe so. Yes. 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 Yes.
So you're fully aware of what is going on, and what you have in the meantime is, can we go to one and then back to the main bundle very briefly? Now, 1215 PDF. This is a document you submit to the DFSA. And if we see the third paragraph, the firm and the present SEO have decided to part ways. The withdrawal forms for alt-in will be submitted by the firm within 7 days of the date on which the CEO ceases to be employed by the firm in accordance with Gen 11.7.1, correct?
In due course, once the date is confirmed, yeah.
Yes. And that is a report that is sent on to, by you to Mr. Gahlowt, correct?
To Mr. Gahlowt and to Mr. Vellucci.
And so if we go up, it'll be a few pages once one gets through, and you'll have to flip around. And there's quite if you could go up quite a few pages. Here we go. That's it. 1190. The DFSA has no comments. Saida did indicate she'll review the IN1 and IN3 when they're submitted. So the position here is that Mr. Gahlowt is under the impression, I put it to you, that the firm is still seeking a replacement, correct? And that there's a hope for an amicable exit. But then you are instructed, are you not, to file a form IN3 terminating Mr. Or duly terminating Mr. Gahlowt, once approved, of course, by the DFSA. So you're instructed to do that by Mr. Vellucci, is that correct?
Yes, I would do it via instruction.
And 190 of the, go to the supplemental bundle, please. $187. So you've told what's happened. George Cole, that's someone in Mr. Vellucci's private office, correct?
Yeah.
And you say I need to stay independent as much as possible, but put it to you that inevitably you are taking your instructions from Mr. Vellucci as the UBO, correct?
I was representing co-investing at the time, but as I said, independence is key for me, and I didn't want to side with anyone, so I just instructed George to collect the documents.
If we go down to 190, this is the form. Now, can you, if we go down a bit, this form, if we go down to the bit it says who's, I don't want to put words in anyone's mouth. Could we just keep going, please? Yes, so here it says contact details of individual completing application, and that's you, to cut to the chase. And then we go down a bit further.
Yeah.
Keep going, please. And then it says select the basis of your authority to sign, and then we go down, director of head office and or controlling entity. But then it says there, I, Enzo Napoleon Vellucci, state then. So can you explain this? Was this a form that you submitted on your own or on his instruction, or how did it happen?
No, on instruction. So I would have received instruction to submit an IND3, and I could not sign this document. It had to be signed by Mr. Vellucci. So I made the application on behalf of the firm, but it was signed off by Mr. Vellucci.
And when you say signed off, how does this actually happen? Does he appear in your office with a pen, or does it all DocuSign, or how does it work?
Not necessarily. Not in my office. He could have. I forget how this one in particular was signed. He could have signed a resolution. Sometimes he could have signed the actual application. He could have uploaded. He could have uploaded an electronic signature. Various ways to sign documents.
But putting it simply, you in your capacity as a compliance officer, you weren't just going to sort of submit this on a flyer. You needed him to be signing off on this, correct?
Correct.
And if we go up, please. We see here, please indicate the reasons for withdrawal. And then it says withdrawal of offer of employment.
Yeah.
So it's not a resignation, it's not a dismissal, but it's a withdrawal of an offer of employment. Did that make any sense to you?
Well, clearly there was negotiating of salaries at the time, so it wasn't accepted according to Enzo's view, and that's one of the reasons for. That was one of the reasons for why Amitesh did not remain as a licensed director and the SEO.
And the short point about this is that we've now just looked at 2 DFSA reports, one after the other, both completed by you.
Yeah.
And the first one of them refers to him leaving employment, and the second suggests that he'd never been employed at all. I mean, do you see that there is an obvious inconsistency between these documents?
Can you go back to the first document where I say employment?
Yeah, by all means.
Yeah.
It may even still be up if we're lucky.
Hopefully.
It's down here.
Okay. Where? Sorry.
Third paragraph.
The firm and party ways. The SEO ceases to be employed by the firm, but that's just semantics. So in my compliance manual, AML manual, etc., I club. This is an internal semantics for me. In my compliance manual, AML manual, corporate governance, risk, etc., I club directors, outsourced service providers, vendors, etc., all as employees. So that's an internal definition that I have.
What I suggest to you, Mr. Aslam, is you've referred to the importance of independence in your role.
Of course.
But what has happened very simply here is you've received a series of instructions from Mr. Vellucci. You have followed those instructions, and that is what you have done. I mean, you've submitted the forms, and you've submitted them. In the case of the IN3, that wording was the wording approved by Mr. Vellucci, correct?
Correct.
And
those were instructions from the director and SEO, director of the business.
Yes, I'm not saying you've done anything wrong here. I'm just saying, I'm just clarifying what's happened.
No, yeah, of course.
So just to be clear about this, if you're appearing to give evidence for the defendant in this action. The case is that you have, when there has been this parting of ways, which is what we're looking at here, there's been a parting of ways, and Mr. Gahlowt has gone on one side, and you and Mr. Vellucci have gone on another. Would you accept that's the case?
I don't accept me and Vellucci are partners in this application. I am here to give answers to the best of my knowledge and belief, and my emails have demonstrated independence and objectivity at all times. So I'm here to assist the court.
Yes, no, I
reaching its
understand that,
conclusion.
but I'm not saying that you're trying to. I'm simply saying that. Well, the way I put it to you is this: if you stand back from the detail, the suggestion that someone would serve as SEO for 8-9 months without being paid is simply ridiculous, isn't it?
Each case is done on its own. Each circumstance, each firm have their own remuneration structure. It can be ridiculous. It can be par for the course. As I said, most in my humble experience, 10 years, most directors who carry out other functions like CIO or chief investment officer or chief risk officer, they're not always remunerated. So that was for Amitesh and Enzo to decide, not for me.
Yeah, but I've asked you to stand back from this. It's not as if Amitesh has got some sort of from your, I mean, you at one stage were friendly with Mr. Gahlowt.
Of course, I would still like to be friends with him. To be honest with
and you know that his, I'm sorry to be a bit, we're in a court of law, but let's just cut to the chase.
Yeah,
he is short of, he wants to be paid, he wants money, and he's not being paid. I mean, the idea that someone is going to stick around for indefinitely in an unpaid role in the circumstance that he is in is not realistic, is it?
That's not for me to answer. I don't know what the conversations were between Amitesh and Enzo at the time.
Okay. Well, if you wait, the next question is, can I ask you whether you had any involvement in, the final question is whether you had any involvement in the issues around Mr. Gahlowt's visa cancellation, because there's a very short issue here, and I just want to know whether you were involved in this from a compliance standpoint or not.
From a compliance standpoint, no. I wanted to help to resolve it.
And just to put it very simply, there are two types of visa cancellation. One is a form that says, I'm not owed anything, it's all fine, and the other says there's a dispute. But in both cases, you can cancel a visa, correct?
If both parties agree to that, yes. To the best of my understanding, if both parties agree to that.
And the position here was that Mr. Gahlowt was not prepared to sign a form saying there's no dispute over my dues, and therefore the visa was not cancelled. Is that your understanding?
It was my understanding. My understanding was there's two ways in which we can cancel. One is dues all paid, one with dues not paid. One or the other weren't going to agree. It was a live discussion that was happening between the defendant and the claimant at the time. And
ultimately, it had to be resolved by a court letter, correct?
Ultimately, yes, it was resolved by the court. Yeah.
Those are my questions. I'm grateful.
Thank you, Doctor.
Thank you very much indeed. Do we have any questions in re-examination?
Just one, I think, actually, if you could pull the page up that was just on screen and just leave it there. I think, yes. You were asked about this document, and particularly the sentence that says the withdrawal forms for AUT-IND will be submitted by the firm within 7 days of the date on which the SEO ceases to be employed by the firm in accordance with Gen 11.7.1 in due course once the date has been confirmed. We see obviously that extract refers to Gen 11.7.1. I think when you provided your answer, you made some reference to a compliance manual. Now, I don't expect that you have recall of every part of the DFSA's modules,
No.
but if I read 11.7.1 to you, and I'll ask you a question. 11.7.1, this is the general manual of the DFSA handbook, says, an authorized firm must request the withdrawal of an authorized individual status within 7 days of the authorized individual ceasing to be employed by the authorized firm to perform a licensed function.
Mm.
Now, when you provided your answer saying that in this form, this was just semantics, having seen the provision of those rules, can you clarify what you mean by that?
What I mean by the word employed in this context is in my compliance manual, and in my compliance manual, I club licensed directors, outsource vendors, outsource service providers as employed because it's easier for language purposes, for manuals, for them to comply with the rules. In this context, Amitesh was a licensed director. So it serves a different definition as an employee. He was a licensed director and an SEO, which means that he can't be a senior manager. So senior managers must be employed. Licensed directors are not required to be employed. But the word employed here was just semantics for my purposes with my manuals.
Okay, thank you.
Thank you. I don't have any questions for you, Mr. Aslam. Thank you for your assistance to the court. You are now released and free to go. I think we're now...
Thank you, Judge. Thank you, everyone.
Thank you. So we've now completed day 2. Thank you very much for your efforts to make sure that we finish at a reasonable time. I'm most grateful. And we will start tomorrow with closing submissions. Are we okay to start again at the same time? I would appreciate that, but I thought I should just double check, because again, I don't want to run up against time at the end of the day. I want to make sure that I'm always able to give my full attention, which is easier if we start earlier, but I'm happy to hear you.
I'm obviously the having cross-examined, I go straight into closing submissions, which I will do. The one point is, I think that I would normally hand up something in writing as well to save a bit of time, and I would normally promise to, or try to promise to, get that to court before I actually start speaking, but I'm afraid that won't be possible. But probably at 7:57 a.m. I hope it will be a little bit earlier than that. A document will come. I don't know whether Mr. Doherty is doing likewise, and whether we should try and swap anything in writing. I don't know where we are on that.
Are you talking about a short aid memoir of 1 or 2 pages?
No, I would be thinking of something sort of, it's really like the skeleton, but just sort of slightly amplified to take account of evidence, really. But what I'm trying to avoid is a sort of full written closing. I mean, I'm slightly in the hands of my learned friend. Well, not in the hands, but I'd wonder what my learned friend is planning to do.
I don't think that we had contemplated written closing, so I'm not going to be able to be in a position tomorrow to produce lengthy written closings, and I didn't think that was flagged at the PTR. I didn't think it would necessarily where it's being a memoir, but we proceeded on the basis that we were closing orally, and that there were points we wanted to deal with in writing, that they would have been in the skeleton arguments on a 3-day trial.
Okay, well, yes. Well, I find it can be helpful to hand up something.
I have
but,
no problem with an aid memoir. I do it often as
Yeah.
counsel, but it's usually quite short, or sometimes
Yes.
it's just transcript references. But I don't
Yes.
know. I don't have a transcript yet, unless you're
Well,
relying on the
that-
team's transcript. We don't have an accurate transcript. That's
We
for
don't have a
certain.
transcript. Well, that's actually one of the issues I was considering, and whether one might have to do it like, dare I say it, in the old school employment tribunal days of sort of just trying to put it all down yourself, which is a hazardous exercise. I think that I may hand something up, but I'm trying to avoid a doorstop. So I think that's it from me.
Yes. Okay. Well, great. I will see everybody tomorrow at the same time that we started at today.
Can I just clarify one point? There was talk of narrowing the list of issues.
Yes.
I've obviously been cross-examining today, but it would be useful to know very briefly from the defendant in particular whether some issues are off the table. If something, however terse, can be sent to those instructing me, it would be appreciated. That would be that.
Starty, is that something that you have been thinking about and that might be possible? Because I think it will be helpful for everyone, if
Sure,
possible.
I'll meet with my instructing solicitor and see what we can cut together with the claimant's lawyers.
Yes, so we'll start tomorrow just going through the list of issues, if we can narrow, reduce any of them. I am using the list of issues. Again, I may not necessarily deal with them in the same order as they appear in the list of issues, but I do find it some helpful roadmap because there's quite a lot of both factual issues and legal issues in this case. If we can, we don't have to go through them, issue by issue, but if we can make sure we address them tomorrow, I would find that quite helpful.
I agree, Your Honour. And yes, I think that what I'm going to be having to do is to refer to quite a lot of, we have got, Your Honour will be familiar with the authorities bundle, and I am going to have to spend quite a lot of time going through that, I should say, on various points.
That's not an issue at all. But yes, if we can, I would like to make sure that I know what the party submissions are on each issue that remains after we have had a discussion about what remains tomorrow, because it just makes it easier for me when deciding the issues. Right. Thank you very much indeed. See you tomorrow.
Thank you very much indeed.
Thanks.